Good morning, everybody. Bonjour, bon dia. So I hope I've got it correctly. Thank you very much for joining us this morning. Hope you have had a peaceful sleep and that you feel energetic and ready for today. And I'm sure you will have the information will just be as valuable as shared yesterday. As you know that a game is always about two halves. Yesterday we had the first half and today the second half. So hopefully we will, sometimes the games are win in the second half. So let's see, let's hope we have that finish until the end. Thanks again for your participation. As you know, we shared much information yesterday, and thanks again for all the moderators, the panel members, the presenters, discussions, and everyone that stayed connected throughout the session yesterday. Thank you very much. So what we have done before we start with the actual discussions or the sessions or with session 4, we prepared you some of the highlights just to refresh your memory of yesterday. So I will quickly share the highlights of yesterday with you. We also, before I share, let me just say this, that I mean, following to the highlights of yesterday plus the discussions of today, we will put that together in a summary report, the detailed summary report, which we will compile after the event and draft, and then once it's ready, we will share it with you as well. So, but be with us. Make sure that your language choice of language are made, and let me start sharing the highlights of yesterday. So we realized, I mean, what we've been discussing yesterday, and it's clear that that landscape has evolved, and there's much more complex financing opportunities available to government. And we also know that there is some differences between government and the creditors in terms of incentives and objectives. There is also internal conflict of sometimes differences within the Ministry of Finance between the technocrats as well as the politicians. Technocrats wants to focus on cost, and where the technocrats want to have the project implemented, and also they want the buyer, the voters recognition through that. So yeah, so it's much more challenging these days as a debt managers. So with all these challenges, and we need to make sure that we are skilled enough for what we need to do, and therefore we need experts. So expertise in various areas. We spoke about yesterday that public debt managers are not lawyers, and vice versa. So some countries hired these expertise, but it's important that these skills are transferred at the end of the day, that you build your capacity in-house, but also very important that you keep these skills, your legal advisors or your financial advisors close to you, so when you need them, they are available. So then in terms, we spoke a lot about transparency yesterday, and so in what we realized is that there's a lot of stakeholders involved in our activities, especially when we negotiate debt. Stakeholders like Parliament, the SOEs we spoke about, line ministry, ministries of justice even, and very important, the central bank, to involve the central bank. So different roles and responsibilities, but for each of them need to understand their roles and responsibilities. Then we had a very interesting presentation from South Africa, where there was a lot of information shared in terms of good practices for sharing information, the media releases when they, after the issue, after the deal's finalized, reviewing problematic clauses, we spoke about that, and also investor relations website, the budget documents, the debt management reports, and the calendars, the auction calendars, as well as the event calendars, and also most important that we put together debt procedures manual that include the role and responsibilities of all actors. So very important that when someone wants to deal with a specific country, that they understand the rules of the game. Yeah, so we also spoke about legal requirements and the legal aspects, and also financial analysts. So in terms of the legal, important to have a legal framework, to understand the outline the authority of borrowing, and also important for debt managers to be aware of the international laws and regulations. We also shared presentation by Ghana, Mr. Samuel Akus, which outlined in very detail what is required in terms of the different risks that's involved, the financial terms that one needs to consider, how you assess these financial terms in terms of your debt sustainable through debt sustainable analysis, your medium-term debt management strategies, and it's all to access the risk and the cost at the end of the day. And we also spoke about the fact that there's sometimes there's cost hidden in these words, and one needs to be aware of. So by doing your financial analysis, it's a good way to strengthen the government's negotiation position. So today, so lastly, in terms of, we also flagged quite a number of problematic clauses, and I'm sure we will have much more clarity after today in terms of these clauses. What was mentioned yesterday was the waiving of sovereign immunity, indemnity, cross defaults, confidentiality clauses, and what we pick up was that there's quite sometimes it's quite one-sided and open-ended, which make it difficult. So for today, I'm sure we will have a much better understanding of this, of these legal clauses. It will be discussed in our next session, and then we will end our last session with the options and opportunities for restructuring. So I think all our debt managers are in some way involved to a lesser or a more extent to restructuring or reprofiling our debt portfolio. We're also going to have to talk about the China approach towards restructuring, and all I can say is please let's have interactive discussions today. Share your questions in the chat box, but also indicate to the moderators if you want to come and present your case or ask questions to the panel. So that's all that I have for now. I'm going to hand over to Rodrigo Colivares Caminal. He is a professor in banking and financial law at the Queen Mary University in London. So we're very honored and privileged to have you on board, Rodrigo, and I know you have a lot of experience that you can share in the African continent. So thank you very much, and I hand over to you.
Thank you, Johan. Good morning, everyone. It's a delight and an absolute pleasure to be able to moderate this first session. For good or for bad, you are stuck with me for the whole day because I'm moderating this first session and then I'm a discussant in the second session. So I would like to start by thanking CABRI for having involved me extensively on this second day, the trust that they have deposited in me. And a big thank you also to not only Johan, but also to Nick Cole for inviting me to perform these two roles, and also to Shakira Mustafa from ODI, who established the link. I will, before I introduce the panelists and discussants of this first session, I would like to pick on 2 or 3 comments that Johan made on his summary from yesterday's session, because I think that he pinpointed a couple of very important things. The first one is he was talking about DMO offices and the role of the people there. And one very important aspect is that he says they are not lawyers, but the reality is that what we are dealing with is something that touches upon many legal issues, and it's impossible to completely separate them. And there's even another dimension, which is political as well. But as technocrats, it will be preferable to leave that one on the side, but we cannot ignore the legal dimension. And the reason why I'm telling you this is that some of these clauses might sound daunting, obscure. Some of them, as Jim and Nicole will explain, even sports, a little bit of Latin. But you should not be put off by these issues. On the contrary, you should try to understand what is the purpose of the clause, why the clause is there from the creditor's perspective as debtors, to be able to, if you understand the reason and the difficulty in removing them, at least you know what is the purpose, and then you will see how you can tweak those clauses. I'm sure that as Nicole and Jim will tell you just in a few minutes, absolutely every single clause can be slightly tweaked to better reflect your position or to better protect your interests. I don't want to steal Jim's and Nicole's thunder, but I wanted to make that point because the role, in my view, the role of the debt management officer is to be able to sit on a table and have an informed discussion with the lawyers, not just blindly say thank you and just stamp or sign the documents. Your input is way more valuable. Sorry, Jim, I'm not trying to diminish the role of the lawyers. I'm a lawyer myself, but basically your input, I think it's way more valuable than that of the lawyers, because this will be your loan agreements. This will be your loan documents. What we lawyers do is we try to reflect your intentions. We try to document what you're trying to do to prevent potential pitfalls. But you need to own your documents. The second issue is that Johan referred to problematic clauses. The clauses are not necessarily problematic. They can be better drafted, badly drafted. You can have a more demanding creditor, or which sometimes become a pain in the neck. But the clauses, they don't need to be problematic per se. They can become problematic if you do not fulfill your obligations, or if you have drafted them in a way that they can give room for different interpretations. And that's why I think that this panel is so important. And the last comment is the Chinese approach. I think that referring to it as a Chinese approach is too broad, because it depends on who the lender is. It depends on the type of debt obligation. it depends on multiple factors, whether that is guaranteed, secured, unsecured. There are multiple things that will condition what is referred as the Chinese approach. And each contract is an individual universe, if you want. So we need to go on a one-to-one basis. But again, I think that basically these issues and many more will come up in the discussion. So I am thrilled to be moderating this first panel, where we have Jim Ho. He's a partner at Cleary Gottlieb, and he has extensively worked on several of these deals, on these transactions in the African continent and beyond. We also have Nicole Kiers, a senior legal counsel at the African Legal Support Facility, who will be doing a presentation to help us understand the key legal concepts and the room that we have for maneuver, or to, as I was saying, to tweak these clauses for your own interests. After they do their presentation, we will have two discussants. Maris Waneira, she's the Director of Public Debt at the Ministry of Finance of Uganda. And we will also have Kanji Liu, who is a partner at Pinsett Masons in Beijing, China. In addition to that, in this first panel, I know very well, and I have worked in the past with Nicole, Jim, and Maris. And Kanji, we become new acquaintances, but hopefully we have agreed that we will have a very dynamic panel. I would like to invite the discussants as we go along to interrupt the presenters. I will be doing the same to elicit all the know-how that we can from their presentation. They are very experienced, very knowledgeable, and I have the duty as moderator to try to make sure that the message comes very clear across. Well, there's not a particular message, but basically what they have to share with us. So help me in doing that. And I have already posted a message on the chat, but I would like to strongly invite you to post questions, and I will be picking up those questions and asking them to the presenters myself. So without much further ado, and very keen in listening what you have to say, Nicole, Jim, the floor is yours. And bear in mind that I will be interrupting you and asking questions. So apologies in advance.
Okay, good morning. Thank you very much, Rodrigo, for the introduction. So Jim and I, as you mentioned, will be covering the first part of the session and focusing on negotiating facility agreements and bonds. Okay, I think we can dig in and start with the next slide, please. So basically, before we start with the actual terms of the credit agreement, sorry, not credit agreement, debt documentation generally, I do want to highlight a couple of points that are on this slide to kind of frame the overall part of this session of this section of the conversation today. So the first is that the underlying theme for this part of the session is really that key provisions in debt documentation are open to negotiation. This is the point that Rodrigo made. This is a point that was brought up yesterday. I will not say that you stole my thunder, but that is definitely the focus of today's session. So what does that mean? That means that all the documents that are provided by lenders should never be taken at face value or as sort of containing some sort of objective truth or reality. And what we also need to remember is that these debt documentations are most often provided and drafted by lenders' counsel, which means that they're necessarily drafted with the interest of the lenders in mind. So as borrowers, we should make sure that we're always carefully reviewing any and all debt documentation before signing it or signing off on it, as the case may be, to ensure that the provisions that are contained in the documentation adequately protect the sovereign borrower, that they're able to be complied with, and that, more generally speaking, that they're fit for purpose, that they serve the purpose they're meant to. The borrower also needs to make sure that it fully understands and has assessed all risks that are associated with entering into the debt arrangement. So even though this session is going to be looking at key provisions, what we do also need to keep in mind is that the entire document needs to be reviewed in quite some detail. And this includes the definitions and the so-called boilerplate language or the standardized language. The second point that I want to draw that's written on the slide in front of you is that in negotiating debt documentation with lenders, it's really important for borrowers to understand what their negotiating power and their leverage is. There are, of course, several factors that might influence or impact a borrower's negotiation power. Key amongst them is one that we've been talking about for the past year and a half or so, since in particular in the context of the pandemic, but the credit rating of a borrower will be important in terms of determining negotiation power. But other factors such as the lender's appetite to lend, market conditions will also impact the borrower's negotiation power insofar as it will impact or influence the lender's openness to negotiate. So yesterday, one of our panelists mentioned the importance of negotiating skills. And of course, those are important. But in addition to that, and where we're going to focus today is on understanding where we can negotiate. And Rodrigo mentioned that, all these agreements can be tweaked, but it's also important to understand where and how, in what way. So that's what we're going to try to do today. So can we have the next slide, please?
Nicole, one question, sorry,
Sure.
if I can. On the previous slide, you were talking about that the room for negotiation, it says, will depend on its credit rating.
Sure.
Why this is so? Why it's dependent on that?
Well, we know what a credit rating is. That basically that is basically an assessment of the borrower's potential for not repaying, right? So why is that important? You are going to be able to negotiate or have more leverage in negotiating any debt documentation if you have a better credit rating, meaning that your likeliness to repay on that debt is a higher chance than a lower chance. So that's what we mean by that.
Thank you, Nicole. So what this reflects is those lenders that see that there's a greater risk in you being able to repay.
Exactly.
We'll try to negotiate stricter terms to be better protected.
That's good. Yep. Thank you.
Thank you. No. But those were your words. I was just making sure that. Thank you, Nicole. Thank you very much.
Cool. All right. So we're going to look at the debt documentation itself now and digging into these key provisions that we promised to focus on today. Starting with the representations and the warranties, which are kind of the earlier on standard representations and warranties that you'll find in a credit facility here. So what is a rep? Representations are just simply statements of fact made by the borrower in, as I just mentioned, a credit facility that are true on the closing date of the debt documentation and when repeated. And I'll touch on that in a moment, what I mean by repeated. Representations, why are they important? They are used by the lender as a basis on which to lend. And they, of course, say certain things about the borrower that supports the lender's decision, such as, for example, the borrower has the authority or the ability to enter into the transaction at all. So certain representations such as, let's say, for example, the transaction is valid and enforceable, that will be typically confirmed in a legal opinion. This will be provided by external counsel to the borrower. In the sovereign context, this will typically be done by the Attorney General. So what is the purpose of this, the legal opinion? It's primarily to give the lenders additional comfort in making the lending decision. So representations are made, as you see on the slide, at the time of the signing of the facility agreement and each time that the borrower borrows or draws under the facility. And these are here are repeating representations. In the Loan Market Association form, or the LMA form, the veracity of the repeating reps is a condition precedent for lending. So just a quick note, not all reps should be repeating or will be repeating reps. So as you see as well on the slide, a breach of a representation is an event of default and can result in a draw stop, which will give the lender the right to refuse to make further advances under the facility. Can we turn to the next slide, please? Great. So here, as you can see, there are actually several examples. I'm not going to dig into all of them, but if you have a quick look, you can see the types of representations that you might find in a credit facility. So what are we here for? We're also here more to talk about negotiation, the room to maneuver. So what are the negotiation points here for reps and warranties? So here, borrowers should really be looking for places to qualify representations. So for example, we might want to add language saying to the borrower's knowledge, or we might make reference to materiality, such as saying that there's no, you see that on the slide, there's no material as opposed to regular litigation. So we would say there's no material litigation as opposed to there's no litigation, full stop. Borrowers might also want to look for places to carve out certain things. So for example, going again to the litigation example, you might want to say there's no litigation except for the litigation that is contained in Schedule X or Y or whatever. And this here will give the borrower more breathing room in terms of what they've agreed to in the representations and warranties. So we've given it a little bit of flavor here, not too much, hopefully not overly complicated detail on reps, but we're now going to turn to Jim, who can also
Nicole,
introduce himself.
Before that,
Please.
you said on basic representations, you can limit how sensitive this will be by including the word material.
Mm-hmm.
How can we define material? Because what might be material for you might not be material for me, or the other way around. Is there any way in which we can limit or establish what material is?
Yeah, no, that's a good point. So as I mentioned in the beginning, we talked about making sure that you're reviewing the entire agreement, right? And so one of the key portions of the agreement that I also mentioned were the definition section. I think, materiality and material is obviously up for debate, but one way to make sure that you kind of are on the same page in terms of what you mean when you say material is making sure that there's a definition that corresponds to material. So that I would say is actually an area of negotiation in terms of the debt documentation and what we mean by material. But the way to deal with that, I think, primarily is to make sure we're defining what we mean by material up front, so that carries through the entire debt documentation.
Thank you, Nicole. And probably that can be with a pre-established quantum. Anything in excess of X.
You can do that, yeah. You can use thresholds, but we've also seen, just clear definitions as well.
Thank you, Nicola. Maris,
yeah,
our discussant would like to do a contribution. Yes, Maris, welcome.
Yes, thank you very much, Nicola. And on that issue of material adverse effect or change, we have tried on several occasions to get our lenders or creditors to define and to also have it on the other side. If they consider something as of material adverse effect, why not also on the borrower side? And all of them have failed to agree. We've always failed to agree on this. So what exactly, why should we have such clauses where the lenders don't want, they're not flexible? That's what they don't want to define it fully so that it is clear. It is always vague the way they define it, so we can't tell when is it going to be, when will it be seen that there's been a case of material adverse effect. So maybe you can expand a little bit on that.
Maris, before I go back to Jim and Nicole, I think that the word material appears on two occasions here. One is in the context of basic representations, and there's also in the information or factor representation when we talk about the material adverse change clause. Are you referring to the latter? I think that you probably would be referring to the latter, but I'm not sure, Mari. That's why I want a clarification on that before I go.
To the
latter.
Yes.
Okay. Before I hand over to our presenters, Kanji has his hand up. I don't know, Kanji, if you want to join into this debate of material.
Yes, I do, and without trying to steal Nicole and Jim's thunder, I think putting on my lender's hat, I think the difficult issue is defining materiality. So whenever when I act for lenders, sometimes we do get asked to define materiality, but nobody can ever define it in a way that everybody's happy. So typically, the compromise is, as Rodrigo pointed out, oftentimes we end up with a material adverse effect definition and importing that into some of the representations. Second thing is that one thing that you commonly see is a very blunt approach where borrowers try to add materiality into everything. And usually that's a sign where there's a lot more negotiation to be had, because there are certain things. For example, the borrower says, I have not breached, I'm in compliance with my own constitution, for example. That's not appropriate to be qualified, but that's one view. Obviously, when you represent the borrower, you have a slightly different view. That's what the lawyers are there for. So back to you, Rodrigo. And
thank you very much, Kanji. I think that rather than back to me, I think it's back to Jim. Jim has his hand up as well.
Sure. Hi, good morning, good afternoon, everyone. As much as I would like to hate to disagree with Lenders Council, putting on my risk counsel hat on, I agree with Kanye that a blunt approach is not a good one. You can't just add materiality to everything. You need to be a bit more specific about that. And ultimately, I think materiality thresholds in this context, when you deal with most of the RAPs, it tends to be more qualitative than quantitative. So, an MAE definition would usually say something that has a material effect on broadly three categories of things. So one is the economic condition of the borrower. I'm talking about in the context of sovereign, right? Two is the ability of the borrower to perform its obligations under the document. But that can also be narrowed down from the perspective of a borrower. So you can say, to perform your payment obligations or delivery obligations if you're dealing with this. And third, this is probably a non-negotiable for many lenders, which is the material adverse effect on the validity or enforceability of the finance documents. Because if the documents aren't enforceable or valid, the lenders will be running for the woods. Nicole, you're going to say something?
No, I was somewhat agreeing with you. I was thinking about where you were saying that you can't go and add materiality everywhere, except for the fact that you would do that, right, as a kind of a negotiation maneuver, and to have some places where you can say, okay, fine, I'll give on materiality here, but in this case, I won't agree to X, Y, Z. So
yeah, but it's all open to
still a negotiation tactic, right?
Can I wear my pragmatist hat? Neither the lender nor the borrower hat. I will wear my pragmatist hat. And tell me, please, everyone, if you disagree, but as a lender, you will prefer materiality on everything because you can bring the borrower to the table to renegotiate any term. As a borrower, you will not want to have materiality because you will prefer to have black or white triggers. I mean, clear-cut triggers, not having these 50 shades of gray that you do not know whether it's material or not. So, and again, trying to, apologies, because I know that we lawyers, we prefer to discuss clause by clause and probably ad eternum, but from the perspective of a debt management office, you might tell me it's too simplistic and I can live with that, but probably those things where you can anticipate, for example, if there are no lawsuits in excess of 250,000 USD, you can clearly define material there. But if there are no material adverse condition to the economy of the country, then possibilities there are almost unlimited. It can come from a pandemic, an earthquake, a drought, a flood, or mismanagement, or a terrorist attack, anything really. So materiality there might be different, and materiality also depending the period of the year, and also depending on flow of funds, etc., can also be relative in a circumstance like that, which is so variable. So can we say that in those areas or situations where you see that you can define by probably establishing a quantum, it would be advisable? Those where it is very difficult because there will be probably 6 pages of different quantums for different scenarios, probably that's when you think that probably some degree of flexibility or different shades of gray might be a better outcome?
Yeah, no, that's a good point on the lack of clarity around the definition of material, and from the borrower's perspective. So I would agree, but I would also say that I would still argue to have materiality, because it's just it's a lower standard in a way, but with clarity around what we mean by material, and that could be a threshold as you suggested.
Thank you. Next slide, back to Jim.
All right.
Sure. Slide 5, please. Yep, so drafting for sovereign. So in case it's not clear already, it's a truth quite frequently overlooked that sovereigns are not corporates, and yet sovereign borrowers are frequently served up first drafts of papers that are more suited to corporate debtors than sovereigns. So just yesterday, I received the first draft of a loan agreement presented by the bank to a sovereign client. And one of the items in the long list of conditions precedent is that the bank would like to receive the annual financial statements of the borrower audited by the accountants, right? Of course, countries do not prepare audited financial statements the way corporates do, but these things happen all the time. So as you can see on slide 5, and also a repeat on this on slide 7 later, there are numerous provisions that might appear to be pretty standard for corporate borrowers that are not always applicable to sovereigns. And in their place, other more sovereign-specific provisions may be included, which we have listed down there as some of the examples. But let's look at one more closely, and the one I want to pick on is the third bullet relating to insolvency. So this is almost universally included in corporate loan documents, right? So this is based on the premise that when a corporate borrower goes bankrupt, the company can be liquidated and its assets can be distributed to its creditors. Unfortunately, no such process exists for a sovereign. And that's why Rodrigo and I know we're in the business of sovereign debt restructuring. So when a sovereign defaults, no insolvency practitioner is appointed to conduct a fire sale of the sovereign's assets to repay the creditors. And the fact that sovereigns do not go bankrupt the same way that corporates do is perhaps the most fundamental theoretical principle that underpins what makes a sovereign debt contract quite different from a corporate debt contract. And this theme will feature time and time again throughout this discussion, ranging from discussions on the pari passu clause to sovereign immunity, which we'll talk about later. Let's move on to the next slide quickly. So covenants are not dissimilar to representations. So like representations, a typical debt instrument would include a section on covenants. So this is a long list of thou shalls and thou shall nots. So from the creditors or lenders perspective, the covenants are there aimed at containing certain risks relating to the borrower, such as credit risk, jurisdictional risk, legal risks, etc. For example, your lender will not want to see you breaching sanctions or anti-bribery laws, because that would then result in a non-compliance of such laws by the lenders. And therefore, that might include a specific compliance with laws undertaking in your contract. So whatever the lender's demands are, it is very, very important to you as a debt manager to balance those demands with your ability to manage your activities on a day-to-day basis. So when you review the list of covenants and also representations presented by the banks, you will need to keep, I think, broadly 2 things in mind. First, you should aim to keep the cost of complying with those covenants to a minimum. And from a debt manager's perspective, this means that you should ensure that the covenants across your financing portfolio are as unified and consistent as much as possible. I can tell you that nothing will give you a bigger compliance headache than having mismatched covenants across your debt portfolio. The second thing, which we've already talked about briefly, is that you should ensure that the covenants, the representations, the EODs do not interfere with your ability to run your activities in the ordinary course of business. For example, sometimes lenders want to put a debt incurrence covenant in your contract, but you should not agree to a blanket restriction on debt incurrence or any other incurrences without any carve-outs. Think about what exceptions you need. Think about, as we talked about earlier, materiality thresholds. Think about monetary thresholds. These are the thoughts that should run through your mind as you review the list of covenants presented to you. As Rodrigo said earlier, and also Nicole repeated this already, don't just say thank you and accept the wording, right? We are, as lawyers, are here to help you as debt managers to achieve your goals, to prevent any potential pitfalls in the future. So Nicole will now highlight an example of a clause that could be both a covenant and also a representation, which is the pari passu clause. Rodrigo wants to ask me a question.
Jim, no. More than a question, is just to make a point, to make sure that this point comes across very clear.
Yeah.
Covenants are obligations to do or not to do something.
Correct.
While representations are statements of fact to induce someone to enter into the contract.
But there is an overlap, right?
There are two different types of clauses that you will find in your debt instruments. One is a statement of fact, the other one is an obligation to do or not to do.
Yeah.
On that point, before we go to the overlap, Jim was telling you, be very careful with the covenants, because this is what you are solemnly taking an oath that you will do or that you will not do. And bear in mind that you need to make sure that what you are signing today must be valid throughout the loan, the life of the loan, because if not, you will be in breach of the contract.
Completely agree. You need to future-proof your contract. Yeah.
And on this note, this is what Nicole is going to tell you, is that basically sometimes some of these obligations or representations, or these covenants or representations, can be combined together in a single clause. So you might have a clause that is half a representation, half a covenant. So it has elements of both. But Nicole, I have a comment from Kanji and Maris.
Yep.
Maris or Kanji, I don't know whose hand was first.
Maris, please go first.
Okay, thank you. Thank you very much. And the question is representation vis-a-vis covenants. And earlier on, Nicole had talked about most cases, these agreements are prepared for the benefit or in the interest of the lender or creditor. So now I bring my question. Most cases, actually, for Uganda, the financing arrangements that we've had. Now I'm looking at the non-traditional, the not IMF, I mean not World Bank, not IMF, not ADB. Those ones, the agreements are clear and the drafting is clear. I'm looking at these commercial, semi-commercial financials. We pay for the services of the lawyers. Okay, we paid for the lawyers. That's a requirement, part of the arrangement. Then they come up with these agreements, and they have a long list of representations, and then the covenants. We discussed all of them, and for the covenants, we try our level best to make sure that these are the things that we can do or we are committed to. Representation, we always tell them, because they bring everything, some things that we are not even applicable. They even bring some corporate related requirements like what was said earlier, those that go to corporates, not sovereigns. And they say these are standard. These are standard requirements. If they don't affect you, they will never be invoked in any case. So they should still be there because they are standard. So I'm wondering, whether these lawyers really are serving us or they are serving the creditors, and yet we paid for them. And then stating that these are standard, they are standard, they're international, they appear in all financing agreements of this nature, we should skip them, since in any case, some of them will not be applicable and therefore you will not have to adhere to them. So why is it so? Is it true that we have standard clauses that cannot be edited in? For Uganda, they have to stay there even if it was meant for another country. I mean, it seems these lawyers come and just edit an old agreement and leave some things in there, and yet we paid for that service.
Well, I'm not sure that which volume you use, Maris, but I know if you.
I'm sorry, but that is
I'm sure we'll tell you that nothing's set, everything's negotiable. Because otherwise, you know, they'll put ridiculous things in your contracts, like you should deliver financial statements or comply with financial covenants that are more applicable to a corporate, or you know, they put restrictions on no mergers in relation to a sovereign, which frankly is kind of meaningless. So I think, you know, you should always push back, and there's no such thing as like a standard loan agreement, like you know, a Tolstoy and unhappy family, each unhappy loan agreement are unhappy in their own ways. They're all slightly different. So Kanye, you're going to say something?
Yeah, so just three quick points. One is on hiring lawyers. Just because you're paying for them doesn't mean they work for you. Okay, because the standard, the typical practice is that banks will hire their own lawyers, but their fees are paid by the borrowers. In that case, they don't work for you. Okay, that is why you should have your own counsel, because without that, you're literally showing up to a boxing match without your own boxer. Okay, so you're jumping to the ring yourself. So that's number one. Two, I think in terms of sort of representations and warranties and covenants and all that, I think putting aside the legalese, I think the way I look at it, and this is with my borrower's hat on, is look at warranties and representations like a health checkup. Okay, so it's something that you say to the lenders, right? Look, this is who I am. And once, you know, every 6 months or a year, you say, look, this is still who I am, right? So whereas covenant is something that you promise to do in the future. Okay, the problem is a very common trap, and this is in the vein of what Jim said, is that sometimes you see inappropriate drafted documents. So sometimes they want you to do a health checkup every day. Okay, we have seen those documents, right? So representation is repeated every day. Okay, if you see that, that's not appropriate. Okay, even for corporates, that's not appropriate. And third, yes, there's no standard on loan agreement. There is a reason why they all tend to look similar, but the devil's in the details, right? So everything's negotiable, to some extent. They want their money back. They want to minimize the risks when it comes to lenders. But you should and do try to negotiate. I think coming from, again, from the lender's perspective, the worst case scenario that we fear the most is a borrower that doesn't negotiate, because you worry that they didn't read the thing, because you're counting on both sides to understand what you're signing up to. That's all. Thank you.
Thank you very much, Kanji. And if I can take an intermediate position between what Maris and Jim said, what you need to bear in mind, and this is relying on something that Nicole said on the first slide, and something to which I brought your attention. A lot of this will be dictated by the amount of risk that you, borrower, pose to the lender. And this is where these links, and Nicole used a very colloquial word, but one which is quintessential in international finance contract, which is stickiness. Some of these clauses, some of these provisions are there because they have been there forever, because they have some kind of mantra of sanctity that they are there. There must be a reason. Even if you don't know what's the reason why they are there, they remain there because in the past there have been no defaults, or if there have been defaults, you've been able to collect on your money. But what you need to understand is that lenders want this clause to be there, and they would like this clause not to be amended because they give them additional reassurance. So this goes back to the first opening comment by Nicole. Well, probably I think it was Nicole's second bullet on the first slide, which is the negotiating power that you have. And this has to do with your financial standing, your political and economic risk, and many other elements that will dictate how much, and this is goes back to Mari's question / comment, is how much room of maneuver do you really have? By default, the clauses will stick there. You might be able to tweak them a little bit more or less in your favor, but they will be there. Sorry, Nicole,
Yeah,
your surprise with this esoteric clause that it's a little bit of a representation and a little bit of a covenant.
Yeah, actually, before I talk about the pari passu, I want to jump in on this and just say that my background is in finance, and I used to represent lenders primarily. And the use of the phrase, "this is standard, you agree to it," is the oldest trick in the book. Everybody tells you, especially when you're a more junior lawyer, just tell them the standard. And it should be pushed back on. And it's not, there's, like everybody's been saying over and over, there's not the LMA form or the New York law firm standard forms are just that. They're forms, and they're meant to be negotiated to make sure that they work for the deal and they work for the borrower. So just to put my 2 cents in there too.
Push back, knowing that most likely they will push back again and you will end up losing, but at least give it a push.
Give the push, and you never know there where,
yeah, exactly.
Where lenders are able to maneuver or happy to maneuver. If it's not having the conversation and not saying, actually, this doesn't work for me, that's the problem. Okay, pari passu. I'm a little bit afraid to dig into pari passu, but so this clause is found in both credit facilities and bond documentation. And it's often one of those clauses that can be confused with other clauses, such as, in particular, the negative pledge clause. And Jim will actually be talking about the negative pledge clause shortly. So definitionally, pari passu means with equal step or on equal footing. And the clause really just says that unsecured, unsubordinated creditors of the borrower will be treated equally. So the purpose of this clause is to prevent a lender from being subordinated to other unsecured, unsubordinated lenders. As Rodrigo mentioned, it is both a representation, and so that will be as of the date of each borrowing, and a covenant to maintain the pari passu ranking of the lenders throughout the debt arrangement. So as you see on the slide here, there are 2 limbs. There's the internal limb and the external limb. The internal limb just says that lenders under the particular facility will rank equally amongst each other. And the external limb says that the debt will rank equally amongst other unsecured debt of the borrower. A breach of the pari passu clause will be an event of default, and that will trigger lenders' actions that hopefully we'll have time to get to today. So in terms of negotiations here, what we're looking to do as the borrower is to limit the scope of the application of this clause. So this could be done by limiting the scope of the application to external as opposed to domestic indebtedness. It could be done by proposing thresholds. We've talked about this a little bit, but material indebtedness, for example. And finally, by distinguishing different types of indebtedness. So it could be between bonds and loans. So I know actually this clause was brought up yesterday as being one of the more complicated clauses, but there have also been a couple of cases that have highlighted the difficulties that courts have had in interpreting this clause. I don't know if we have time to go into this in great detail. Hopefully Professor Rodrigo will have a chance to talk to us maybe about the 2 cases at the end and kind of their impact on the standard ICMA language. If we may move on to the next slide, unless you want to dig in now, Rodrigo, on pari passu.
Nicole, I think that probably we should continue, and then if we have time, we can come back to this.
We can come back.
In a nutshell, what I can say is that there have been 2 international cases, mainly one in Belgium, one in New York, that have led to years of litigation and a very vast academic and policy debate on the clause. Bottom line is that now the ICMA, International Capital Market Association, has suggested a streamlined version of the clause to prevent misinterpretation of the clause and potential litigation shenanigans. And I think that we leave it there. If we have time, I think that probably we can dig deeper in the Q&A session.
Sure. Okay, let's take then the sharing clause. So this is another clause that will protect lenders in a syndicated loan structure. And what this does is prevent the borrower from favoring any lender in a facility by saying that if one lender receives excess payments by the borrower, it will then share that money with the other members of the syndicate. This clause isn't one that's typically negotiated by a borrower because it effectively serves to protect lenders from discrimination by the borrower in favor of under other lenders rather. So this one is actually here because it does also tend to be confused with pari passu and with negative pledge clauses. And unless Rodrigo wants to ask anything, I can pass to Jim, who's going to now tell us about negative pledge clauses.
Jim, over to you.
Yeah, so negative pledge is a covenant, is a promise by the sovereign borrower not to create any security interest over its assets in favor of other creditors. So the basic rationale is quite simple. It is to prevent preferential allocation of assets. Negative pledges come in several forms, whether you're looking at a loan or a bond. So in a loan form, the most rigorous and therefore the most unpopular version of the form is the absolute prohibition on the borrower's ability to incur any future secured debt, full stop. Sometimes you see this, but a well-advised borrower in a DMO is to include exceptions to it. So it would say, thou shalt not incur or create security interest, but for this long list of things. So you can add things like project finance, ordinary course bank liens, and the like. On the bond side, the negative pledge clause is framed slightly differently. So it's what we call like a Me Too negative pledge. So it will restrict the creation of security in connection with other bonds, unless the bond in question is also secured on an equal footing with such other bonds. So in other words, if you breach the bond negative pledge, this can typically be cured by granting equal security to the bondholders of that series. Let's move on to the next slide, because this then ties in all three clauses together. So why did lenders go through the trouble of negotiating clauses such as the pari passu clause, the sharing clause, and the negative pledge clause? If you take a step back, lenders are not just facing the borrower, right? Lenders are also facing the other lenders. So lenders to the same borrower are fated to coexist in a Hobbesian state of nature. So if the borrower gets into financial difficulties, it may well be true that what is good for one lender is proportionally bad for the other. So each lender must keep a close eye on the behavior of its fellow creditors. So the pari passu clause makes the borrower promise that each lender is ranked equally with one another, but that is not enough. The borrower is then made to promise under the negative pledge clause that the borrower will not prefer other creditors by providing security to them, but that is also not enough. So in order to drive home the point that the brotherly bond between creditors is a very weak one, the lenders among themselves are made to promise that if they were to receive a payment that is disproportionate in comparison to the amount that they are meant to receive compared to the other creditors, the excess payment must then be shared with the other lenders. Of course, these are just covenants on a piece of paper, right? So Nicole will now explain how these words are given some teeth under the events of default clause.
Jim,
Okay.
Jim, one question before we move on. Why we don't usually find a sharing clause in bonds?
There are various reasons for it. So one is because a lot of bonds are done under the trustee structure, right? So all payments and everything that you deal with the bondholders are done through the trustee. But the problem is there is also the fiscal agency structure for bonds. And we can go into the plumbing of how a fiscal agency structure works, but that is a little bit more amorphous. And depending on which form of fiscal agency agreement you look at, sometimes they got some weaker form of a sharing clause, sometimes they don't have it all together. So it's basically free for all. So if you owe one creditor $1 and you don't pay them, that $1 creditor can come after you under fiscal agency structure. But under trustee structure, it's all done under, so you need like 25% to accelerate and 50% to rescind, etc. But then all payments from the paying agent to the trustee will then be held on trust for all creditors pro rata. But it's also a function of how loan and debt instrument terms are sticky, right? So they all bear the scars of war. And somehow the sharing clause was just a bigger issue in the syndicated loans market than in the Eurobond market. And therefore you tend to see it more in the syndicated loan. But I think that's probably a topic for your PhD students to research, Rodrigo.
Can you claim that with the sharing clause in a bond, you will have practical difficulties in enforcing it because of how atomized the bond holding is in the markets?
That's right. And also I query how the bondholders can actually go claim on to be paid on a preferential basis compared to the other bondholders, because most bonds are now held through the clearing systems anyway, right? And it's a global node and it's all stuck through Euroclear, Clearstream, or DTC. So there is also a philosophical question as to whether anyone would actually be paid more.
Thank you very much, Jim. Apologies that I diverted onto that slightly more technical issue.
So, Nicole, you want to talk about events of default?
Yes.
Next slide.
Yes, next slide, please. Okay, thank you. So this is kind of a very important bit of debt documentation. These are the events of default. And as you notice, we mentioned a couple of places where we've said, this will trigger an event of default. So here we are with events of default. So these are pre-agreed breaches that allow the lenders to take certain actions. The actions that a lender might take include terminating the commitments to the borrower. They include declaring outstanding loans to be due and payable in whole. In other words, accelerating the loan or calling the loan. They include suspending further loans, and to the extent that there is security, which we've not touched upon in this particular session, but it allows the lenders to exercise their rights in respect of that security. So there's a distinction to be made between default and events of default. So the former, a default, is simply defined as an event that with notice or over time effectively ripens into an event of default, allowing the lender to take the actions that I've just mentioned. So on the slide, there are several examples of events of default. So we're not going to take the time to go through all of them, but do have a look at them and you'll get the slides after. In terms of negotiation, ideally what we're trying to do is, as a borrower, is to limit to the extent possible the number of circumstances that will constitute or lead to an event of default. As you see on the slide, some of the key negotiation tools here are going to be requesting grace periods. So basically allowing time for the borrower to remedy the issue before the default ripens into an event of default, as I've just described. I'm afraid to say it, but we could also add materiality thresholds like material misrepresentation, material litigation. We won't go back into detail on that one, but that's another way. And then there's also, Jim has kind of touched upon this earlier, but to the extent when we're talking about a sovereign borrower, what we definitely want to make sure we're doing is removing any proposed events of default that are just not applicable to standard. I know Rodrigo could talk extensively about the insolvency of sovereigns and its non-existence, but suffice to say that here, what we want to make sure, again, is that this agreement makes sense for the particular borrower, in this case, a sovereign. Can we move to the next slide, please? Great. So staying with the theme of events of defaults, here we're just going to talk in a little bit more detail about cross defaults and cross acceleration, which are another topic that has been talked about widely, in particular in the context of the pandemic and the DSSI and other relief tools. So a cross default is where a default under another obligation that's outside of the facility constitutes a default under this particular facility. And this clause serves to protect the lenders from the potential financial deterioration of the borrower, and ensures that lenders have the ability to react to any trouble with the borrower in a timely manner. Meaning, in other words, that they don't have to wait for there to be an issue under their agreement in order to take some sort of preventative actions. So the cross default provision needs to be distinguished from a cross acceleration provision, which basically says, it's a little bit more complicated than that, but basically says that if a borrower defaults under another financial obligation and the lenders under that agreement accelerate the debt, that will constitute an event of default. So in terms of negotiation, the borrower can request things such as restricting cross defaults to payment defaults under other obligations. So here we're saying, as a borrower, why should something like the failure to supply some sort of documentation or some other requirement constitute a default under this agreement? Another way to look to negotiate is to use materiality thresholds. And here it's a little bit more precise. So here, for example, we're talking about cross defaults related to non-payment defaults under another obligation that are over a certain amount. And that's what you see on the slide, the example of language that might cover that. And then finally, because there is a higher threshold for cross acceleration, meaning the actions or certain activities having taken place under the external obligation, lenders probably prefer a cross default, whereas a borrower here can argue for a cross acceleration. And this again will tie into negotiation power, and leverage that we talked about earlier. So I'm going to pass back to Jim, who's going to take us through sovereign immunity.
Sure. So on sovereign immunity, until about the middle of the last century, most countries recognize an absolute theory of sovereign immunity. So what this means is that foreign sovereigns could never be sued in the courts of another country without its consent. So as countries became more involved in international commerce, the absolute theory of sovereign immunity was gradually displaced by a restrictive approach. So the restrictive theory of immunity denies sovereign immunity to foreign countries in cases where their commercial activities are carried on abroad. So this is codified in the UK in the SIA of 1978, and the US has a similar legislation under the Foreign Sovereign Immunities Act of 1976. So for example, a state will now not be entitled to immunity if it has previously waived the immunity, for example, under the written terms of contract. Immunity will also not be recognized if the lawsuit is based upon the commercial activity of the foreign state. So under this legislation, there are two types of sovereign immunity to bear in mind. So the first type is whether the state has jurisdictional immunity. So that is whether the state can be sued in an English or US court. So with respect to jurisdictional immunity, the sovereign borrower will usually have to agree in a contract to the jurisdiction of an English court in relation to an English law contract, and New York courts for New York law contracts. Sometimes, the borrower could also insist on arbitration. The second type of immunity is whether the state has immunity from attachment and execution. So that is whether the creditor, who is now armed with a debt judgment, can then enforce against the assets of the states in other jurisdictions. This might be a pretty short clause found at the back of the contract, and it's very tempting to just gloss over it and call it a day, right? So you've done 200 pages of loan review, and then now you've got like 2 lines, you just think that's okay. But bear this in mind, it can be incredibly problematic in the aftermath of a debt restructuring when some creditors were not repaid. There are certain categories of assets where you should think about refusing to waive immunity over under any circumstances. For example, you won't want your creditors going after your diplomatic property. You also don't want your creditors going after your military assets. And you certainly won't want your creditors touching your foreign reserves, in times of distress. So, bear those points in mind. And I think, it's very hard to fight the immunity clause. I think for jurisdictional immunity, you can typically say, yes, we submit to the jurisdiction of the English or New York courts. But for attachment and execution immunity, think about that quite closely. Let's move.
Jim, before we move to the next slide, sovereign immunity is one that keeps on coming and coming.
Yeah.
and it was mentioned extensively yesterday. And it's one of those sticky provisions. The question is, what happens if you don't include a sovereign immunity waiver, or why do we need to negotiate extensively a sovereign immunity? Because there are these acts in the US, in the UK, which are the main governing laws applicable to sovereign indebtedness, that will tell you, even if you have not waived, if it's a commercial activity, you will not have sovereign immunity, right?
Yeah, no, that's absolutely right. But why rely on the interpretation of whether something is commercial and a commercial activity or not, right? So putting my lender's hat on, they'll just say, look, there are various exemptions under these legislation. One, no, we're pretty sure this is a commercial activity. You're also representing in your long list of representations that this is a commercial activity. But then ultimately, it's up to the court to decide whether it is or not. What is clearer from the perspective of the lenders is that if you waive sovereign immunity, in a written contract, that definitely works, right? So once you waived it, that works. So that's why, in terms of jurisdictional immunity, you generally have to give it up. But for attachment and execution, you can play around with it a little bit more. Maris, you got something to say?
Yes, thank you. Because in our case, we've tried so hard to get our lenders to consider applying governing laws, being those of Uganda. And we have failed. We've really negotiated that and failed, and we end up with the English law and all that. But we also have, we have banks that are lending to us, and they are based within the region. And we have the East African court, the EALA in Arusha. So we've also told them that, why can't we use our legal body in Arusha for banks that are lending to us and are based within the region? And we have also failed to convince them to do that. But when it comes to the waiver of immunity, we have a constitution which clearly states what cannot be attached. And even with that, they don't respect our constitution. They still insist on having those the clauses there that will look at certain assets that they want to attach. So the commercial, the semi-commercial, financial. So why is it that constitutions are not respected by these lawyers? I thought lawyers should be able to look at such provisions and be flexible to consider what we have in our sovereign laws. And again, we still want to know why we cannot use our court, our regional court, for some of these as governing law, given that some of these banks are registered and based within the region, those that are lending. Thank you.
Maris, just to straighten the record, this is a question that deals with governing law and jurisdiction, not necessarily sovereign immunity, right?
The first one is on the law, and then the second one is immunity.
Fine. I don't know if Jean, Nicole.
Yeah, I think on governing law, unfortunately, this is something dictated by lenders, right? So lenders prefer English law and New York law because they've just been, one is both are creditor-friendly jurisdictions, and two, there's just a longer history of case law and other legislative history relating to the provisions relating to the clauses in the agreement. And so we'll be talking about collective action clause in the next page, and it might seem like again a relatively simple clause, but then it has been used in English law contracts since Victorian times, right? So the earliest cases relating to collective action clauses was in the 19th century. So that's why I think lenders just feel a bit more comfortable using the laws of England and New York. And on constitution,
Jim, before you jump to that one, can I be slightly less politically correct and add a couple of bullets to Maris?
Sure.
Maris, one of the main drivers, if not the main driver, let me start with a little bit the fluffy stuff around this, and then I will go straight for a kill. But basically, English is the law or the language of the international capital markets. They have historically used either English or New York court laws because they protect the sanctity of contracts, what the parties have negotiated, not necessarily some interference that you can commonly see in civil law jurisdictions. And I'm not referring to Uganda as a civil law jurisdiction, but I'm just mentioning this as additional context, where sometimes the principle of good faith might interfere. In addition to that, the other thing that you need to bear in mind is that it has to do with a degree of sophistication, the flexibility of courts, etc., and as Jim was saying, experience in dealing with these matters. Having said all of that, the problem is that, and we've seen this in a recent restructuring, but I'm going to pick a Latin American example in order not to offend anyone. But the problem that we have, Maris, is that in some jurisdictions, the judiciary and the legislative or the executive are not that far apart. And sovereigns have a very powerful tool, which is a lawmaking machine. So I'm telling you this because, for example, a sovereign can pass a law, or the executive can draft an executive order saying courts will not be able to enforce on any contract against a sovereign, and that's it. If it's governed by domestic law, you have the possibility of putting a limit to the rights of creditors. Different is the case if it's governed by a foreign law, and the jurisdiction is either New York or England and Wales. Sorry, Jim. I don't know if you agree with that, and then you have the second part of Constitution. Sorry.
Yeah, no, on the constitutional point, I'm not that familiar with your specific issue, Maris, but just by analogy, we're advising a central bank currently, because of the constitution of that particular country, there's certain subset of assets that the central bank cannot waive immunity over. And we found that the lender was actually quite responsive to, again, very specific exemptions, because it's subject to the constitution. If the constitution says that the central bank can never waive immunity over this particular type of asset, was accepted. So again, it's like most provisions, it's all subject to the specifics of the borrower, and I don't think that you should just think that it's not negotiable, because I think that it is.
Thank you very much, Jim.
So should we move to the last?
Jim, let me hold you on to that, because I have a couple of questions on the chat. And I prefer to squeeze these two questions, and then if not, we will do a 1 to 2 minutes executive summary on collective action clauses. But Kanji, I saw you nodding when we were discussing issues on governing law. Do you have anything to add from your practical experience?
Sure, and typically you have two issues on this particular topic. So one is governing law, the other one is the seat of the dispute. So regardless of whether you choose to resolve your issues in dispute in the court or by arbitration, usually people argue over these. I think that the problem with I think Jim and Rodrigo, you've all talked about the legal issues. Ultimately, it's not wanting to fight the fight on somebody else's court. Right. So from a Chinese perspective, whenever we go to one of the emerging markets, the borrowers always say, I want to use my own law. The Chinese say, I want to use Chinese law. Nobody can agree. We end up with English law. And same thing with dispute resolution as well. So usually people will want a seat in their own country. And China will respond with Beijing. Nobody's happy with that. So we end up with either Hong Kong or Singapore by default, sometimes London. I think one thing very important to note is that this is negotiable, but as when it comes to a specific bank, they are limited by their internal rules. So if you want to negotiate certain things, there is a limit as to how far you can go. So for example, you might be able to find a bank that's willing to agree to Uganda law. That's fine. But for most banks that are operate outside of Uganda, I think that's going to be problematic. Certainly with the Chinese banks, you're unlikely to find them agreeing to a local law, governing law for the facility agreement. And in the last few years, you're unlikely to see them using any US documentation or New York law. So English law is by far the default nowadays.
Thank you, Kanji. Jim, Nicole, before we go into as the CACs, the collective action clauses, I have a couple of questions from the audience. The first one is, what happens if money, I mean interest and capital, are not claimed by investors from the fiscal agent even after maturity?
So I think, one depends on the terms of the contract, but two, it also depends on the governing law. So if it's English law, the limitation acts as that after 6 years, the claim is prescribed for ordinary agreements and 12 years for things done by deed. So look at the contract, and figure out what that is. And also, I think that's probably another esoteric question, because nowadays you just pay through the clearing system, and the clearing system will just funnel it through the entire system, and it will hit the accounts of the investors ultimately. Even if it's not a live account, it will just go where it needs to go according to the clearing system, and it might be stuck at the first level depositories, right? So the direct participants like the HSBCs and JP Morgans of the world. And on the second question on cross acceleration, I think this is probably one of the things that I feel quite strongly about as borrowers' counsel.
Sorry, Jim. Do you mind if I read the question? But I'm not sure if everybody has seen the chat. Jim, on that first question, prospectuses in any event usually include a line on statute of limitations, right? That sometimes, and again,
sometimes it's shorter, sometimes it's 5 years or 10 years as opposed to 6 and 12. Yeah.
And sometimes they amend these to reflect a different statute of limitations, a contractual statute of limitations, which can be shortened or extended beyond what the default law says.
Yeah.
The statute of limitation for contract is. So again, this is another example that what we were saying from the outset, all three of us, well, all four of us and Maris as well, that you can negotiate specifics. So basically by default, you have a law in the jurisdiction that will tell you what is statute of limitations. But besides that, you can reduce that period or extend that period contractually. The second question for Jim and Nicole, it says, is proposed basically whether you are proposing cross acceleration in place of cross default. Do you have any good negotiating tactic, and what is the probability that the lender will accept this proposal?
Yeah. So
as a clarification, cross acceleration, the reason why they're proposing cross acceleration rather than cross default is that cross default is triggered automatically by the default. In a cross acceleration, even if there's a default, you need to accelerate for that default to materialize. So basically to have any of the contractual remedies. And the question is, that seems very appealing to me as a borrower. And then, Jim, I don't know if you can share any of your best kept secrets, how you manage to convince a lender to go for something that will not be much of their like.
Yeah, no, I think this is probably one of the top 5 things that I always try to fight for borrowers, because the reason is, imagine you got 2 loan agreements, right? So you're negotiating loan agreement number 1, and loan agreement number 2, is for a much smaller amount, and it might have a lot of technical covenants that you might breach from time to time, right? So, but then you're negotiating this thing that's like $5 billion, for example. If you have a cross default clause, so basically a breach of that particular small loan, and if, as Nicole said, if it's a technical covenant that you might breach, you're basically incorporating by reference every covenant representation, undertaking in that other loan agreement into this present loan agreement. And that cannot in principle be right. if the lender wants specific covenants for this particular $5 billion loan, negotiate it here, right? Don't just incorporate by reference through the cross default clause. And that's what I usually argue, but I'm sure Kanye will argue otherwise.
I would like to actually add to, part of the question is how do you do that? And I think it also comes back to what we started with, which is negotiation, leverage, credit rating, those types of things will allow borrowers to say, no, I want a cross acceleration, not a cross default. And so it's really about understanding where you stand kind of in the market, but figuring out where you can negotiate in this and try to push back to the extent you can.
Thank you very
just
much,
a very
Nicole.
quick point here.
We have
Oh,
Kanji,
sorry.
who was invited. No, Kanji, please. You were invited by Jim to comment on this, and Maris has raised her hand as well. So Kanji, you go first, and then I go to Maris.
Yeah, so actually, one very common approach to negotiating across default into a cross acceleration is to sort of deal somewhere in the middle. So one, you either built in some sort of a de minimis threshold below which things don't count. The two, one of the problems with banks agreeing to a cross acceleration clause is that they have no transparency as to whether you agreed to a cross default elsewhere, right? So there's always a feeling that they're losing out, right? So sometimes, the bank then counter that as well. Then they give me a covenant that you will not agree to a cross default. And of course the borrower said, oh, no, we can't do that. So typically you see a lot of these back and forth quite a bit. And as Jim said, absolutely right. A cross default imports covenants from a different document. That's why people love it. But if you don't have it, what that means is in a restructuring or a default situation, the lenders sitting on the cross acceleration as opposed to a cross default tend to be slower to come to the table. So they don't like that quite so much. I think to close off, I think to negotiate a cross acceleration clause with the Chinese lenders nowadays, very, very rare. Okay, 10 years ago, it's probably much more common. Now, I think things are becoming much more standardized. I think lenders can expect probably, unless it's a concessional loan, then there's more room. Otherwise, if you're dealing with a commercial bank, I think you have probably less than 5% chance of getting away with that one.
Thank you, Kanji, for sharing your data. The chances of success, but that's very illustrative because they say it is quite difficult. It is quite difficult to manage to get it done. Maris.
Yeah, thank you. Mine is just to seek maybe guidance on this. Is it possible for this clause, if it has to be there in the agreement, to restrict it to facilities of similar nature? For example, if we have a financing agreement with this partner, maybe we restrict it to another financing agreement that we may have committed to earlier, instead of also having this apply to other arrangements. I want to give an example of what we recently experienced. We have a financing agreement with a bank, but this bank had also invested in a government agency. They had, through a different financing, it was more like a contingent liability for that agency, where they lent some financial support. Then this agency so happened to go bankrupt. It's now under liquidation. So what happened is that this bank decided to hold on some funds that were supposed to be disbursed to support the budget, on condition that we first make good of what was due to them from the other agency that is currently under liquidation, before they can disburse the funds that they held onto on the financing facility to government. So what kind of cross default was this? We failed to understand up to now, because our understanding was that it will relate to another loan or credit facility to government, but not applying to other engagements that they've had with other government agencies or SOEs. So how can we avoid such a situation so that we don't have this?
Yeah, so if I understand correctly, it's just what kind of other defaults, cross defaults into that particular loan or bond that you're looking at. I think it very much depends on the definition of indebtedness, capital I. So it could be indebtedness, which is probably the broadest, so you just capture all sorts of debt. It could be financial indebtedness, so capital F, capital I, financial indebtedness, and that will be monies borrowed and bonds and loans and things like that. Or it could be external indebtedness, so it could be external financial indebtedness, so it's loans or debt denominated in a foreign currency, right? And then if you're dealing with bonds, then you're looking at public external indebtedness. So it's not only the loan or the other debt must not only be denominated in a currency that is not your local currency, but also the debt has to be a listed debt. So for example, in Eurobonds, it's probably more common for the cross default or cross acceleration to cross from public into external indebtedness of other kinds. But for loans, for example, I've seen it, everything from indebtedness to financial indebtedness to external indebtedness. So I think, for that particular analysis, you really need to look at the specific definition. Nicole, I see that you've unmuted yourself.
No, I've been unmuted.
Okay.
Thank you. Thank you. Johan, can we have 2 more minutes?
Yes, no problem.
Thank you, Johan. So, Nicole, Jim, you have a huge challenge in front of you. You need to do CACs in 1 minute, so we have another minute to close the event. So
I'll try my best. It might take 2 minutes since it's such a large topic. So on collective action clauses, so one of the perennial challenges of any debt restructurings is the specter of holdout creditors who did not participate in the restructuring. So corporate bankruptcy codes typically have some method of imposing the will of the majority creditors on the naysaying minority, but we don't have that in a sovereign context. So without a bankruptcy code or court to help facilitate this process, sovereign debtors facing a workout will need to find a way to deal with non-participating creditors in a different way. So the collective action clause is a contractual provision that permits a specified supermajority of holders to agree to a modification of the instrument. So the will of the supermajority, for example, 75% of the creditors, will then bind any dissenting minority holders. So I already said that CACs were pretty commonplace in both corporate and sovereign bonds governed by English law since Victorian times, and because of different legislative history under New York law, but they started to feature more prominently in New York law governed sovereign bonds since 2003. And ICMA has also published a model collective action clause in 2014. So that's the bond wall. But one point to note is that while CACs are pretty common in bonds issued by sovereigns, the amendment provisions in many sovereign loan agreements still require the consent of each lender. So in effect, you need 100% lender's consent when you propose changes that relate to a money term, for example, reduction of interest rate or extension of maturity date. So this means that in a loan, the dissenting view of one minority lender could potentially scupper the entire amendment process. That's 2 minutes, Rodrigo.
Jim, thank you very, very much. Before I bring this to a close, Kanji, Nicole, Maris, anything else to add?
I would actually just like to, well, first of all, thank everyone. I think it was a really useful and interesting conversation. We didn't get a chance to talk about what the ALSF does more specifically, but my kind of ending plug is that to the extent these clauses are confusing rather, and to the extent people or countries need help in negotiating them and kind of figuring out when and where to push back, how to push back, that's what our bread and butter is at the ALSF. So please feel free to reach out for any assistance that we may be able to provide in that manner. That's it for me.
Thank you very much, Nicole. Maris and Kanji have both unmuted themselves.
Nothing from me. Morris, all yours.
Thank you, Kanji. Maris?
Yeah, thank you very much. I want to appreciate the clarification given by the team. And we actually hope that we can have more of this because we still have challenges in convincing our lenders to be flexible on matters of indemnity, where we pay costs that we think are not supposed to be borne by us, and arrangement fees. There are a number of things that we think need to be, maybe it is about negotiating, but we've done our best. And we still feel that these partners of these creditors should also, maybe the way we approach it could be the problem on our side. But we look forward to further engagement in these areas. We will approach the ALSF for support where necessary to strengthen our negotiation skills. And that's all I have for now. I want to appreciate CABRI for arranging a very good team.
Thank you very much, Maris. Just as a wrap up, and also to facilitate Johan's work to summarize the session, I will just kind of list 3, 4, which are in my personal view as moderator. I'm not doing this on behalf of the speakers or discussants. It's basically, you need to remember that usually the lender has the upper hand, and this is summarized as money rules. Second, you need to remember that the stickiness of these clauses, this is tradition, this is what my grandfather has seen in the contract, this is what my father has seen in the contract, this is what the senior or managing partner of the firm has included in the contract that he has shared by email, a draft template that I can copy and paste. So these clauses are there to remain there. However, despite having said and mentioned the stickiness, try to negotiate every single clause. Anything can be negotiated. And on that note, Maris with her question and Jim with his answer kind of steal my thunder. I was going to tell you that one of the things that you usually overlook are the definitions. And with Mary's question, it was so evident because for the pari passu clause, for the negative pledge clause, for any of these clauses to be operative, usually you make reference to indebtedness, be it indebtedness, be it financial indebtedness, be it external indebtedness, or the other issue that we discussed extensively, materiality. And these are just definitions, and it is a tendency for us to think that definitions, okay, these are just standard terms, so or this is a standard definition, and there are, I can look you in the eye, ask you to cross your right hand across your chest and lift your other hand and tell me how many of you read a dictionary. None of you read a dictionary. I mean, for pleasure. I mean, probably you go to a dictionary to ask to find out the definition, but you don't read this. But in a contract, we must read definitions because they are quintessential, because the pari passu clause or the negative pledge clause will not be operative. The cross default clause will not be operative without the definition. And that definition is what we determine how sensitive the cross default, the cross acceleration, the pari passu, the negative pledge clause are. With that, I hand over to the organizers, and I apologize on my behalf, the presenters and the discussants, because we have exceeded 8 minutes.
No problem at all, Rodrigo. Thank you very much for this. I mean, very interactive information. I'm sure that we all are actually, looks like we have to go back to the drawing board as debt managers. And I mean, in my days, I was always leaving this for the lawyers to, and never actually take or took the time to understand these clauses. And I think it's a lesson that we as debt managers should learn, that we should take these clauses much more seriously and understanding them much better. So thanks for your summary at the end. We will definitely include that in our highlights or our key messages. Thanks for this interaction. I also now understand what is the oldest trick in the book. I mean, if they ever comes to me again and say, this is just a standardized clause, I will understand where that comes from. What I also would like to sort of bring to the attention of all the participants is that Nicole and Jim put together, and the team put together a background paper on all these clauses and understanding of these legal terms. So I would really recommend that we send it to you. We will send it again. So please look at those background paper for better understanding. So yeah, thanks very much. I was very interesting. They say if you put lawyers in a room, you can just lock that and throw the key away. They will talk on these things forever. But thank you very much for this, and make it very understandable to us as date managers as well. So yeah, so
Johan, we will not even notice that we are locked in that room. We will even have fun in that room.
Okay, no, that's what it's all about. We will even put a bottle of wine in there.
I will definitely make it better.
Okay, so then thank you very much. I think let's move over to our next session, session 5, which is the last session of the day, and I'm looking very much forward to this session as well, is on assessing the opportunities and options for restructuring. So I think as debt managers, we are all faced with high debt levels, and we don't know how much our interest rates will eventually crowd out other government expenses. So for this session, we have Stanislav Nikata, from the director from Debt Management Program in MEFMI, who looks after Southern and Eastern Africa. And I'm sure, Stan, you can also share quite a lot on these. And I'm sure we will have just as interesting and exciting discussion on these topics as well, especially with, I'm going to be very cautious now not to say the Chinese approach, but because these are all contracts are individual contracts on its own, but we will have a Chinese perspective on in terms of restructuring. So over to you, Stan.
Thank you so much, Johan, and let me thank the CABRI team for inviting us to participate in this webinar, which deals with a very topical subject for many of our countries. The COVID-19, as we all know, has elevated the debt vulnerabilities in many of our countries, and with some countries being reclassified from low risk to moderate risk, high risk, and other countries are already in debt challenges with problems of paying their debt. And for those of us who've worked on public debt management for quite a while, I think this is taking us back to the 1990s or even earlier, when countries were at a similar stage where they had to look at ways of how they could restructure their public debt. Of course, at that time, there were the arrangements, including the Paris Club facilities, the London Club, and with the coming in of the HIPIC initiative and the multilateral debt relief initiative, that helped countries in terms of dealing with the public debt burden. So here we are, almost over 15 years later. Countries are facing similar debt challenges. And of course, maybe at this time, we are lucky in the sense that we have a bit of history, from which we've learned some lessons. And it's not like we're beginning from a scratch. However, with the available frameworks like the common framework for debt treatment, as well as the debt service suspension initiative, we see that countries are still proceeding in a fragmented manner in terms of dealing with the creditors, and some countries are not participating in these initiatives. And maybe again, looking back, previously we didn't have as many creditors as debtor countries. And right now we've got so many creditors, and some of them quite significant. And the challenge for us is how do we deal with this kind of creditors? And also how do we try to bring on board some of the private creditors so that they provide the much needed debt relief to our countries. So, and there's also the issue of how do we ensure that this debt relief is linked to the climate change agenda. So to address or discuss these issues, we've got an exciting list of panelists who are going to give us some very good insights into the issues that countries are facing. So first up, we're going to have Yunan Chen, a senior research officer at the Overseas Development Institute, is going to talk on a very interesting subject for many of us, China. And then we're also going to have some country experiences from Kenya, and these are going to be provided by Mr. Livingstone Bumbe from the Public Debt Management Unit at the National Treasury in Kenya. And then Rodrigo is going to come back. And then we're also going to have Kanyi Lu, a partner Pincent Masons, Beijing, China. And then we're also going to have experiences on restructuring transactions in South America, and this is going to be provided by Graham Stock. So at this stage, let me invite Yunan Chen of the ODI to give us a presentation on Chinese lending and restructuring. Thank you.
Okay, thank you so much, Stan. Just give me a minute whilst I share my screen for the presentation.
Yunan, we are already sharing on your behalf.
Okay, could I share? Because there are also things that I would like to control in the presentation.
Okay, I can stop sharing.
That would be great, thank you. Can you see my screen? I can't really tell what's going on.
Yes, we can.
Okay, I'm gonna put it to presentation mode. Okay, maybe I'll just begin. I think I may have some network connection issues, but hopefully that will resolve. So first, let me just thank the CABRI team, in particular, thank you Shakira and to Johan for your support in producing this paper. In some of the previous discussions we've had over these 2 days around contracts and negotiations, there's been a kind of elephant in the room, which is China. China is obviously a hugely important and influential creditor, but it's still very opaque to the outside world. So the purpose of this presentation is to present an overview of the paper that tries to draw together some of the research and secondary data and insights that have been produced over the last few years. I hope this is a useful synthesis to start a conversation. And I really look forward to the questions and insights from the participants today who have very close experience on site first and a breakdown of what we call China, to distinguish between different Chinese institutions and creditors, to understand how these institutional structures can influence approaches to debt restructuring. And then finally, I'm going to discuss a bit about China's participation in current debt restructuring initiatives, including the DSSI and Common Framework. So first, I'm going to give an overview of China's lending in Africa. As we're all aware, over the last 20 years, China has become one of the largest bilateral creditors in Africa. It's estimated to have lent over 150 billion to governments and SOEs. But there's a very uneven pattern over time and over different geographies. So almost 50% of China's lending portfolio in Africa has been concentrated in 4 top recipients. And over 50% of China's lending has gone towards pretty much 2 infrastructure sectors, in transport and in power, which are coincidentally infrastructure sectors where China supports China's domestic going out policy. There's also a political aspect to a lot of this lending. A lot of it has been tied to the Forum of China-Africa Cooperation, the FOCAC, and increasingly Africa has also been tied into China's Belt and Road Initiative. So these forums kind of set the cooperation agenda, and they can be a platform for new financing commitments and in maintaining this bilateral political relationship. So as a creditor and as a donor, China behaves somewhat differently when we compare it to OECD official bilateral creditors. There's a study from data that shows that Chinese lending and loan contracts seem to be more commercial in character. And this touches on some of the discussions from the previous session. There's a significant use of instruments in these contracts that are designed to ensure a commercial advantage to the lender and ensure repayment. And some possibly concerning no Paris Club clauses. And this is much closer to what you would see from private sector creditors than from official creditors. And the possibilities for debt forgiveness really very much depend on the type of loan that comes from the Chinese institution and the institution itself. So I want to give these loans. And in this chart here, we have from the top to bottom, the different types of loans as they decrease in concessionality. So at the top here, we have the foreign aid loans, the zero interest loans, which are a very, very small portion of the portfolio. These are normally used for economic and technical assistance. We have the foreign aid subsidized concessional loans that come only from China Exim Bank. China Exim Bank and China Development Bank have been 2 of the primary actors involved in overseas lending, and Exim Bank particularly in Africa. The majority or the bulk of this lending has been through non-foreign aid loans, however. These are export buyers credits from Exim Bank and from and commercially oriented loans from CDB. So I'm sure we can share the presentation later, but I detail here some of the typical or some stylized facts around the different kinds of loan terms that you see from these institutions. And so you see that from the big 4 Chinese commercial banks, ICBC and Bank of China, have been increasingly active overseas in the Belt and Road Initiative. And these are also providers of commercial type loans.
Yunan, your audio is cutting off, so not sure whether you're able to switch to sort of a stronger internet, because I see some comments in the chat pertaining to this.
I can repeat what I just said. I don't think I can switch internet connection. It might just be the Wi-Fi cutting in and out a little bit.
Okay.
So if just ask me to repeat the last thing that I said if there's something that you want me to clarify. That might be the easiest way.
Okay, maybe let's proceed and then see how it goes.
Sure. Maybe if there's something that you didn't catch, please ask me in the Q&A.
Okay.
So in this slide, I want to show just kind of where these different loans come from. I should mention Marina Rudiak from Heidelberg University, who developed this of where these Chinese financial institutions sit. So on the left, we have the foreign aid oriented lenders and the commercial lending towards the right here, which sit under the People's Bank of China and the Chinese banking regulator. So from here, I'm going to break this down to focus on the institutions involved in lending and debt. First, for zero interest loans. These, since 2018, have been under the remit of the CIDCA, or the Chinese Development Agency. Before that, it was under the Ministry of Commerce. And funding for these loans come from the Ministry of Finance, which also supports Exim Bank's concessional loans. So because of this, the political origin of this lending, the decisions around restructuring will tend to be more politically driven and in some ways more straightforward. So these are ministries, they are not subject to the same commercial banks. And what we see for zero interest several agencies.
Yeah, you're cutting off. I think as you're talking about this left block, if maybe you can just repeat what you're saying.
Sure.
You're cutting off, yeah.
Mm-hmm. So on the zero interest loans, we have the financing and restructuring decisions concentrated in these ministries. So restructuring of these loans will come directly from a consultative process between the Ministry of Foreign Affairs, Ministry of Commerce, Ministry of Finance, and the CIDCA, China's Development Agency. So it makes it very easy, in a way, to cancel these loans in a sweep. And this has happened several times. Most recently in 2020, we had a cancellation of zero interest loans that were maturing within the year. And this was done in a simple ministerial decision. For policy bank loans, which includes Exim Bank and CDB loans, these are a little more complicated. They are typically never cancelled, but they can usually be restructured or refinanced. But the restructuring process and requests for debt relief occur on a case-by-case basis. You won't see a sort of broad sweeping debt treatment as occurs in the foreign aid zero interest loans. So what we see with these loans tends to be more along the lines of rescheduling, the deferral of repayments, in some cases for export buyers credits, a restructuring of loan terms. Usually this is what we see as an extension to the maturity, and in some rare cases, haircuts to the interest rate. Negotiation processes also differ between Exim Bank and CDB, even though both are policy banks. Exim Bank is considered more state adjacent because it is the only bank that offers concessional loans that are subsidized by the state budget. And so a loan restructuring of concessional loans does require a government-to-government negotiation and agreement, which is not the case for the commercial loans from CDB. I'm going to skip ahead here. So with commercial loans from CDB and from the other major commercial banks, such as ICBC or Bank of China, these banks are much more commercial in character. They act autonomously, and they are also subject to greater regulatory pressures and also competitive pressures, because they are also operating as market actors. makes them much more constrained to be a no-go. So any restructuring that does occur tends to preserve as much of the loan's net present value as possible.
You were cutting off, so maybe in summary, what kind of relief can countries expect if they are negotiating for debt relief on the commercial loans? You were cutting off. Maybe if you can just try to summarize that.
Sure.
Yunan.
So with these loans, rescheduling is probably the most favorable option that you would be able to obtain. In general, for these commercial banks, as long as interest payments are being met, it is possible to defer repayment of the principal. But because of the commercial and regulatory pressures that they face, they are a lot more constrained in the type of debt relief that they can offer.
So is it under the same terms as the original loan? That is looking at the interest, the applicable interest rates, or what is it like?
I think changes to what we've seen from past precedent is that it tends to be a process of kind of rescheduling, allowing for suspension of repayment on the principal. So the scope for flexibility is a lot smaller compared to what we would see from Exim Bank.
Thank you.
Or the more concessional loan types. These more commercially oriented loans require risk insurance from Sinosure, which is the state-owned insurance company. And this insures these lenders against repayment defaults from political commercial risks. In general, Sinosure can cover up to 95% of the loan cost. It also means that if there are any issues with repayment or in the event of default, Sinosure comes into play. And Sinosure can play a quite decisive role in overseeing and approving any loan final approval. So they are a small, but they can be critical actor. Some sort of general takeaways from this. To summarize, the more commercial the loan, the more difficult and perhaps narrow the scope of possibilities for debt relief. We're very, very unlikely to see debt forgiveness when it comes to commercial loans from Chinese financial institutions. Something else to emphasize is also the very strong hierarchical nature in the decision-making of these banks. Requests for debt relief really have to be approved from the top down, and any request for changes in commercial loan agreements really depends on decisions from first from the credit committee within the bank and then from the board itself. This is something I think Kanye will also discuss, but factors such as personal liability and precedent within these Chinese institutions is also extremely important because bankers stay within the system. Any decisions that they make that lead to financial losses for the institution will have personal repercussions for individual bankers. And so this means that there is a broad tendency to keep escalating the problem upwards, and this can lead to a prolonged or a slightly foot-dragging approach when it comes to dealing with debt issues. Political signals and international and China, this has in the past been somewhat influential to a country's ability to change the terms of their Chinese loans. This has sometimes happened through using the FOCAC forum or other summits as venues for political diplomacy. The involvement of international actors, particularly the IMF, can also crowd in parallel interactions with developing countries. And in some ways, China can take a more long-term relationship-oriented view. What this means is that there is sometimes more space for flexibility with borrowing partners when compared to other commercial creditors. But negotiating capacity of borrowing governments, the negotiating capacity of borrowing governments and national frameworks around debt also matter. So laws that mandate transparency can also override some of the contractual requirements that we've discussed around confidentiality. And so this can also be a huge advantage for borrowers. So I'm going to move on to some of the current debt relief initiatives that China has participated in. In the COVID era, we've seen a very mixed approach from China to debt restructuring. On the one hand, China has been proactive in taking part in multilateral debt initiatives, but as the most recent white paper on foreign aid and other discourse emphasizes, China's preference, and it still wants to maintain bilateral channels of negotiation with borrowers. It still wants to maintain negotiations on a bilateral basis. China has joined the G20 DSSI and the Common Framework for Debt Treatments beyond the DSSI, the Common Framework, or I'll refer to it as the CF from here on. And the debt suspension that the DSSI allows is really not a radical departure from China's past practice, but I think it is a politically significant moment that China is participating in these multilateral debt initiatives for the first time, particularly for the Common Framework, because China has previously resisted joining the Paris Club, but essentially the Common Framework it creates a platform for a potential Paris Club light arrangement that includes China and offers a pathway to debt restructuring between multiple creditors. But there are obviously many challenges in the operationalization of these mechanisms. So for the DSSI, the major weaknesses have been problems around the lack of private sector participation, and also limited participation from Chinese financial institutions as well. China's government limited participation in the DSSI only to China Exim Bank, claiming that that is the only official lender, while CDB is kind of ring-fenced as a commercial bank. And this has been due to China's criticism of the lack of World Bank participation. The Common Framework was meant to get around some of these problems, and it goes beyond the DSSI in mandating borrowers to seek comparable debt relief from both official and private creditors. Thus far, China has been relatively constructive in its engagement on the Common Framework. The Ministry of Finance is the institution really driving this collaboration. They've been working with the IMF on technical issues. Exim Bank has been the primary representative in creditor committees for the Common Framework negotiations so far. And I think there is, what this says is that China does view it to be within its interest to support this multilateral solution to debt restructuring. But there are still major questions on how the Common Framework will be compatible with some of these commercial loan contracts from Chinese institutions. Particularly some of the no Paris Club clauses. All right, I'll repeat myself.
Yes,
so there are still some major questions on how the Common Framework will be compatible with China's commercial loan contracts, some of the no Paris Club clauses that we've seen in some of these contracts. The Common Framework is also still extremely thin. It's a few pieces of paper and it's premised on a diplomatic consensus. So there is still very little clarity on the process, the procedures around formation of the creditor committee, how decisions are going to be made. there's also no guarantee or mechanism that can ensure commercial actors such as CDB can be compelled to absorb proportionate losses, which can in turn discourage other private creditors from getting debt treatment. So the common framework is still very much a process of evolution. There's a lot of pressure right now to try and get it right. And we have, the first 3 cases that may be a trial to show whether or not the common framework can work and create positive solutions both for debtors and for creditors. If it does result in good outcomes, then the common framework could become more of an attractive measure rather than as a last resort. However, I think, shall I repeat myself? I think my internet cut out.
Yes, please.
Okay, just to re-emphasize, the common framework is still in a process of evolution. If it results in good outcomes for the first 3 cases, then perhaps it can be considered as more of a preemptive solution rather than as a last resort. There are also other more radical solutions that have been proposed in the recent year. There have been proposals from researchers at Boston University that have linked debt relief to climate, advocated for certain countries who are both highly indebted to China and who may also have potential wins in biodiversity conservation or in renewable investment. And I bring these up because there is a potential alignment of interest here with China's own articulated commitments to climate action. China's committed to carbon neutrality by 2060 and increasingly has become more stringent in its overseas development finance to greening the Belt and Road Initiative. There have also been other proposals in the use of Brady-type credit enhancements, Brady bonds, and commodity-linked bonds, which were used in the 90s in Latin America and have also been proposed as potential instruments for African borrowers now, particularly given China's position as a major importer of as perhaps one of interest for borrowing countries. It takes advantage of the natural commodities that many African economies have and uses it to reduce credit risk for the lender, and so may also be of interest to Chinese lenders. These are still proposals. They have not been tried and tested, but I raise them because I think in this time of crisis, there is a perhaps critical opportunity for new ideas and experimentation. And so some of these solutions should not be cleared off the table. So just to sum up, some of the key takeaways, I'll do this very quickly. First, not all Chinese lenders are the same. Banks face very different incentive structures, and this conditions what outcomes for debt relief are possible. Political signals matter, and Chinese creditors can be flexible because there is a much more value perhaps put on this long-term relationship. And although China has signed up to the common framework, its impact and reach still remains limited. So the recommendations I think to take away here are first, that we want to break down this homogenous idea of Chinese lending, that you really need to understand the incentives and the political context of the institution you're working with. As I said before, China as a lender has some advantages over other commercial actors. There is a possibility for flexibility, but this relies on maintaining a good relationship, both at the political level and also with individual institutions such as Sinosure. Three, domestic, some of the more ominous confidentiality clauses that have been raised as concerns around some Chinese contracts. And it can be a way to strengthen the position of borrowers. Also contains the word for opportunity, but I think in this period there is a space for radical proposals and innovations. The common framework is still relatively untested, but it could be a useful instrument if it works. So borrowers should really try and push harder on participants in the common framework to clarify the process, to strengthen communication on exactly what it entails and what the procedures are. Borrowers should also look carefully at opportunities for new debt relief instruments, such as the Brady bonds, or in aligning debt and climate goals in restructuring possibilities with both China and also with other creditors. I'll stop there. I apologize for any cutouts in my internet connection, but I look forward to further conversation on this. Thank you.
All right. Thank you so much, Yunan, for that presentation. I've got one question. You talked about the issue of commercial debt, where for China, I think the scope for debt relief on the commercial debt is somewhat, or is narrow rather. So, I think in one of the recommendations you're making is that there's need to build relationships between the creditors and China. I just wanted to know from you what your thoughts are in terms of escalating such or dealing with these issues at a regional or continental level, given that China has got relations, for example, with developing countries or Africa, maybe as an example, and then issues being dealt at that kind of framework. What are your views on that?
So there is, to date, there has been, I think, a lack of coordination between African borrowers on this issue. And China's approach in its diplomacy with African countries, even though it has the Forum of China-Africa Cooperation, even though it hosts all of these multilateral summits, it's still very much a hub and spokes approach. China does not have an interest in working with Africa at a regional level on this debt issue. As a lender, as these commercial institutions, they do want to preserve their discretionary advantage in how they negotiate, and that is why bilateral negotiations are the preferred option.
Okay. Yeah, that's quite interesting, because I would imagine
I think something that has been floated. Hello?
Yes, you can proceed, please.
Sure. In joining the common framework, African borrowers
there's a breakup again.
are sort of, perhaps it may also penalize them in terms of their credit rating, but perhaps there is scope for the common framework to work with African borrowers at a regional level or at a sub-regional level. So if multiple countries from a region come together and try to collaborate or coordinate with creditors within the common framework at a regional level. Sorry, I think my network has cut out.
Yeah.
Let me try and come back to you, and I'm going to try and switch to my phone.
Yeah, I think this subject of China, I think is quite interesting to many of us in this webinar. And I hope that we're going to have some very stimulating discussions on this. So while we wait for you to come back, I think we can go straight into the next discussant, Mr. Livingstone Bumbe from the National Treasury, Kenya. Over to you, Livingstone, for your thoughts on this subject.
Sorry, I'm on the road, but I believe you can hear me.
Yes, we can.
Yeah, so I'll just give an experience of Kenya, whereby Kenya is normally funded by the China Republic, and that is the conventional angle. Then we have China Development Bank and China Exim Bank. You'll find that on the stock of Kenya's debt, that is $3.7 billion dollars. China's stock is $7.1 million dollars. Recently, we benefited from the DSSI, that is the Debt Suspension Initiative, and we had a problem with China, and of which, if I can explain, some extent, on their part, they had some concern regarding contribution to other lenders. You'll find that China, on the concession, on the bilateral, if you look at the portfolio of China on the bilateral side, China leads with 19.9% compared to 7.9% on other bilateral lenders. So on the DSSI that we did January to June 2021, we had a relief of 424 million US dollars. Out of this, you will find that China contributed $335 million. So to say, China had contributed 70%, close to 80%, and the other bilateral lenders contributed to 20%. So then again, we are now having a second DSSI, but this time China has said that it is not going to participate because it sees itself as if it is contributing more share than the other lenders. And as we tried to negotiate with them, and actually they were adamant that this really affected ongoing projects, whereby we saw some slowdown in disbursements, and some projects were now not moving. And as a country now, we said let's pursue these other lenders and leave China out. So I could say that is the problem of how Kenya's portfolio is, how portfolio looks like, because now China is the leading, and now because now if you go to the Paris Club way and you say you want to take out some debt relief, going the London Club way, you'll find China again is there, and as you may know, it is not possible actually. Some of our component of commercial debt is the Eurobond, and these ones we cannot touch. So what I could say is that as countries, we need to look at how our debt portfolio looks like, and if your portfolio is dominated by one lender, then they'll box you to accept the terms. Over to you, Nkata.
Okay, thank you so much, Livingstone, for that interesting contribution from Kenya. And I would imagine that many of our countries are in that situation, in the sense that the proportion of Chinese debt in the portfolio is quite significant. And therefore, the debt service obligations are actually high. And maybe let me request Yunnan for views in terms of how this issue going forward could be addressed, looking at the end date for the DSSI being the 31st of December this year, and looking at the fact that China is not likely to participate in this second phase of delivery of debt relief under DSSI from July to December, and the fact that we're still in an environment which is uncertain. The COVID-19 pandemic are still continuing, and recovery for many of our countries will go beyond December 31st. So maybe you might wish to provide your views whether at international level these issues are being discussed. Thank you.
This is a really difficult question, Stan, which I thank you for. There is a lot of pressure right now on African borrowers, and the fact that China is becoming increasingly recalcitrant around how much debt relief it provides is quite worrying, because to date it has been perhaps one of the more amenable creditors that you can leverage. As I mentioned before, in past cases, what has been successful is often sort of pulling on the political strings and using that diplomatic relationship. The fact that there is another forum of China-Africa cooperation coming up this November, I think it is a forum for African governments to perhaps exert a bit more pressure at the political high level. If there is a directive from the top, if China's top leadership does recognize the urgency of these debt issues, there is potential for a sort of trickle-down effect that can signal to individual financial institutions that they need to do more, and that perhaps they need to be more flexible. But there are also ramifications and perhaps unforeseen implications of choosing this route too. But yeah, I would say that for African governments also to coordinate, to come together, and to not just use individual channels, individual bilateral channels of pressure, but to act more collectively in terms of information sharing through greater transparency, or through sharing their experiences on how to leverage and how to negotiate with China as an actor, I think can also be extremely valuable in this time, because there is a shared interest, I think, in trying to work better with this very large and significant creditor. But I think perhaps some of the other participants also have views and suggestions on how to approach this problem.
Yeah, I think your response is great, Yunnan, and I do hope that colleagues at CABRI are taking note of this. You are specifically mentioning the issue of coordination among the African countries and trying to deal with the issue at a regional or continental level in terms of involving the political leadership. I think that's one of the ways in terms of how this problem could be addressed. And more especially, I'm looking at the bilateral debt that is owed to China. Is quite significant in most of our countries. So yeah, thank you so much for that response, Yunnan, and to Livingstone for your interventions. So at this stage, I would like to invite Rodrigo for your thoughts on this very interesting subject. Rodrigo, over to you, please.
Thank you very much, Stan. Thank you for inviting me to participate in this panel as well. I'm going to be slightly more provocative because I think that we are taking a given stance and I'm not sure where we are departing from, right? I have two issues, one at the China debt level and another one at the borrower level. The first one is, who is to blame, the sheep or the shepherd? And the question is that we are talking about debt write-off, debt restructuring in instances where we need to start by asking ourselves whether the money has been borrowed, whether the money has been received, and then why we should just stop paying the money. And I'm not talking specifically about China, I'm talking about creditors in general. And as debt management officers, I think that basically this is something which is very important. If we are borrowing the money, we're receiving the money, then we have a validly entered legal obligation that we have voluntarily incurred. So why do we need to depart from the presumption that we should not pay it? And I understand that there can be change of circumstances, etc., and then you can negotiate specific waivers. But I think that we are departing from a slightly misguided approach in the sense that the money has been lent, the money has been received, so then otherwise we will be willing to rewrite legal contracts, so basically how lending arrangements in general operate. On that note, then what I would like to say is that I think that we are looking at this from the wrong angle because we are looking at the ex post consequence rather than looking at this ex ante. We should be questioning whether we should be preventing or curing the problem, because now I think that we are arriving late. I think that the main issue here is prevention, not curing, because the moment that we have to restructure the debt, it's too late. There's a huge political cost, there's a huge social cost, and of course, needless to say, there's a huge financial/economic cost. So my recommendation or my suggestion to debt manager officers is we need to start, or we need to rely on three key pillars. The first one being due process. And when I talk about due process is start by a proper law and economics analysis as to whether there's a need for the incurrence of the debt. Then what will be the contribution to development? And I put the emphasis on development, not just financing budgetary gaps. And what are the future prospects, or what are the chances of future prospects, and what can interfere that future flow of funds in the development cycle. Then the second pillar or building block should be transparency, where within transparency, I think it's important to have a proper recording, proper budgeting, and also use this transparency for accountability purposes. And the third pillar, I would say, is the rule of law. And when I refer to the rule of law, I mainly think of using the rule of law to fight opportunism, and unfortunately, in some cases, to fight corruption. So I think that the whole issue of looking here at this and trying to blame China or saying we should have a regional approach to negotiate with China, I will like to turn around and ask you whether you have a regional approach to negotiate with the IMF, with the World Bank, with private creditors. And the short answer is No. So why China would be different? You can tell me, well, we have the aegis of the Paris Club, but basically in the Paris Club, it's for sake of simplicity. But other than that, you don't have a common approach to negotiate with creditors. And the other comment that I have, Stan, I don't know if you would like maybe the other comment, I think this is on China. I don't know if because the other comment would be on DSSI and the common framework. I don't know if you want me to make a comment or a remark on that now or probably later. You're muted, Stan.
Oh, sorry. Yes, maybe on this issue where you are talking about or emphasizing the need for prevention being better than cure. I mean, which I entirely agree with you. The need for due processes, contribution of the loans to development, transparency, as well as the rule of law. Indeed, these are important, but why this issue of engaging China at a different level is because there is an issue at hand. Countries have to make that difficult, or governments have to make those difficult decisions of how do they allocate the available resources in this very difficult environment towards debt service, which is significant, but also other pressing needs of the government. I think that's why this issue of trying to engage creditors like China, who are most of our countries are indebted to. That's why that issue of re-engagement is coming up, because there is an issue at hand, and how do we deal with that issue? And I would imagine that's why we are having this discussion. But I entirely agree with you. Prevention is better.
Stan, we have clearly instances when we have a temporary or short-term trigger shock, which is what I think you're referring as we have the issue at hand now in the COVID environment. But the problem is that we also have some medium to long-term rooted structural problems.
Exactly.
And we know, people inside this room, this virtual room know, and we don't need to point fingers or give names, that some of the issues that we are blaming now China for, and don't get me wrong, I'm not making a case for China, I'm just plain devil advocate here, is that many of these problems were pre-pandemic. And that's something that we also need to acknowledge. And sorry if I'm playing devil advocate and doing the acid test, but the reality is that in some instances, the problems were pre-pandemic. Now we are blaming COVID-19 and trying to take advantage of the environment to gain breathing space or do some kind of temporary arrangement rather than solving the underlying structural problems. Sorry if that's my view, Stan, and I stand to be corrected, but apologies if I'm being too blunt or direct on that issue, but that is my view on that particular aspect. But
yeah, I mean, you are making a valid point, Rodrigo, because I think there are structural issues which our countries have to deal with. I mean, which you have ably clarified. But I think in the course of all this, acknowledging that yes, we have to deal with the issues, but of course we also need to see how best we can take advantage, or I mean, how can we leverage on relationships that are there to deal with the issue. So yeah, but I fully understand your point of view. I see a hand up from Neil.
Thank you very much. I mean, mine is going to be partly a question, and maybe that question is to Yunnan, and that is, I mean, does a common approach not better support improved transparency? Because the way that one would think about a common approach is not just the basis for the negotiation or the negotiation itself, but what is the basis of that negotiation. So if one was to think about the World Bank or the IMF, and there are governance indicators that inform the basis for the negotiations that countries undertake individually, I mean, with the World Bank and the IMF. And that brings a commonality into the negotiations because they're informed by a common set of indicators and how countries score against those indicators. And I mean, I'm not familiar with what led up to the decision to have a move towards a common approach in the negotiations with China. But I would think that if there's a positive that one can draw out of it, is that it does lend itself to improved transparency. Thank you.
I'll try and do my best to respond to that. I wanted to just first jump back on Rodrigo's earlier comment, and I think, you know, I agree with him. I think he makes a very valid point about, you know, there were structural issues even prior to the pandemic, but I think this juncture right now where you have this dual crisis of both a health crisis and an economic crisis, you know, we don't have the time to go through all of these bilateral negotiations and ensure a fair and equitable outcome in every single one, right? I think there is a degree of urgency here that maybe makes a common approach or some degree of coordination between borrowing governments. It makes it a rational option or a strategy. In terms of having a common approach, as Neil was discussing, I think what you're saying is maybe governments that share common aspects should try and work together. Is that an implication of your comment? I think something that perhaps Chinese creditors don't have yet, or maybe you can correct me on this, but you know, there is this maintenance of bilateral channels in China's the relation of Chinese creditors with each country, but perhaps there does need to be more of a collective approach from the perspective of Chinese financial institutions in how they engage with borrowers of different types. Obviously, with the very, very large sovereign borrowers that have been significant partners of Chinese lending, probably you still need to maintain a discretionary bilateral channel for that. But for the cluster of you know, borrowers that are relatively small or have not are not as significantly indebted to China by volume, I think it does make sense for Chinese financial institutions perhaps to take a similar approach to perhaps what the World Bank does, and having more of a clarified, transparent, common approach in debt restructuring and negotiations there. Kanye, do you want to come in on this point?
Sure. Thank you, CABRI. Thank you, Yunnan. Thank you, Stan. I think in discussing this particular issue, it might be useful to just set out a couple legal limitations that we actually face in China, that the banks face, in fact. Having acted for a number of sovereigns on restructurings, I think it's important that you're aware of this before you start or before you proceed further with negotiations. The first is the concept of personal accountability. Okay, what that means is that the banker that you speak to as part of the original loan remains, and his manager and his manager's manager or her manager's manager all the way up the chain remains personally accountable, not liable, accountable for the performance and recovery of the loan. Okay, so as a result of that, so if you, and this point didn't come up during the last session, there is a practice to actually loosen up covenants and different contractual terms so that borrowers do not easily trip over them. This is very different, okay, when when you're dealing with a Western commercial bank, okay, because the Western commercial bank's approach when I act for them is to tie you up throughout the contract, whereas the Chinese will try to loosen the covenants so that you don't inadvertently trip over them, okay? Because if you do, then it goes up for review and reflects badly potentially for the entire team, okay? 2, there is a duty to recover the principal of the loan, okay? That's non-negotiable for the banks, and that's a very strong requirement, okay? The reason for that is it's not just because they can't lose money, but also losing the principal means an impact on their core capital adequacy issues. Okay, so that impacts on the key performance indicators of each of the commercial banks they deal with, as well as the policy banks in different ways. So I think that's a very important point to take away as well, because in Yunnan's presentation, you'll have seen the organizational chart that she set out. So you have on the left side, you have the Ministry of Commerce, Ministry of Foreign Affairs, SICA, and so on. On the right side, you have the different banks like CDB, China Exim, Bank of China, ICBC sitting along a very different chain of command. Okay, so it's not the case that one of the ministries can just call up a bank and say, look, forgive this loan because it's good for the bilateral relationship. That doesn't work. As a matter of law, no bank, and this applies to all banks in China, no Chinese bank can forgive any loan. There's no qualification without the approval of the State Council. Okay, so when you are talking to them and said, look, I want you to forgive, or we'll band up and, we'll make sure we'll try to get you to take a haircut. They literally cannot do that without the approval from the highest organ in China, literally, barring the Politburo. Okay, so that is your main hurdle that you're dealing with. That being said, if you're dealing with things like rescheduling as opposed to a haircut, if you're dealing with things like waiving certain things, extending the drawdown period, the availability period, waiving certain contractual requirements, what you will find is that the Chinese banks are very likely to work with you. Okay, so having personally been work with them on many of these things over the last couple of years, even before the pandemic, you'll see that there is a high degree of willingness to work with you because personal accountability. They're trying to do everything they can to work with you to preserve the relationship and to avoid a payment default on the principal. Okay, interests are important, but the principle is key. Okay, the third point is Sinosure plays a key role in this. Okay, for most of the banks, barring China Exim and potentially CDB to some extent, but not all, most of the Chinese lenders cannot lend to borrowers in emerging markets without Sinosure insurance. What that means is that you have institutional memory and knowledge in one entity, okay, that literally is able to have a full picture of what's going on. Okay. So what that means is, as Yunnan mentioned earlier, bankers stay within the system. Even if they transfer between the different major banks, yes, they can go into a Western bank and they're out of the system. But as long as they're staying within one of the state-owned banks, they share the same shareholder ultimately. Okay, so the personal accountability stays. Sinosure reports to the State Council directly. So it also keeps some institutional knowledge on how things unfold throughout the years. Okay. So what that leads to is this: things get remembered. So I think one of the axioms that we tend to hear in the bond market is that the market has no memory. Okay, but I think that's not the case when it comes to bilateral Chinese lenders. What that means is, from a practical perspective, is that they're really willing to work with you. They will bend over backwards to work with you, but there are certain lines they cannot cross. Okay, and yes, it's absolutely true that relationship is key, but you have to understand their limitations and how to talk to them. So having worked with them on a number of these things, going to the China, your lenders who are actually on your side on many of these issues and say, look, I don't want to pay you because I have to pay back the bondholders, doesn't fly. Okay, I don't want to pay you back because it's not going to be received very well. Okay, so these are the things that you should, and it has happened. You know, these sort of messages have somehow been communicated, you know, through the years in different contexts. But you have to understand how to talk to them, and they're actually really willing to work with you. So that's something to keep in mind. Thank you.
Yeah, thank you so much, Kanji. I think that's quite reassuring. I do hope that Livingstone is still around the table because Kanji has mentioned the issues of personal liability to staff in the commercial banks and the kind of constraints that this is, places on them. But what I've liked is the fact that there is flexibility in renegotiating the terms. Of course, while the repayment has to be made, but that flexibility, I think it sort of offers a window of hope for countries like Kenya. So maybe for Kenya, or indeed other countries, if they've got experiences in terms of the negotiations at the bilateral level, I think it will be interesting to hear those experiences from Kenya, but also from the other countries. So thank you so much, Kanji, for that interesting insight and clarification. Thank you. Of course, you're one of the panelists. I just wanted to know whether you still have got any other issue to talk about on this subject, or is that all?
No, I think we can proceed and see if we want to discuss anything else.
Okay. Yeah, thank you. I see that we're running out of time. And then we have one more discussant, and that is Graham Stock, Senior EM Sovereign Strategist. So Graham, the floor is yours to give us a short perspective on the restructuring transactions in Southern America. Thank you.
I'm not sure if we lost Graham. We will try to see if we can connect again, but please continue.
Okay. Thank you. So there is a question from Zolani Sandiso to Yunnan. Given the impact of the COVID-19 pandemic, what is the risk of the level of default by African countries in honoring their repayment, and what's the extreme recovery strategy by Chinese lenders? Of course, I know we've had discussed this, but maybe if you'd like to have to give some more thoughts on this.
I can sort of address the second part of the question. I think the first part on the risk level of defaults, probably best to go to the assessments from the IMF and the World Bank on various countries. You know, as we've seen, that COVID has pushed a lot more countries onto the brink of debt distress, or push them into high risk of debt distress. In terms of honoring repayments to Chinese lenders, the sort of past experience that we see is that, as Kanye mentioned, you know, a lot of the time there is a lot of scope for flexibility and accommodation in deferring repayments on the principal, as long as you maintain the repayments on the interest. There have been, in rare cases, restructurings of the loan terms to make them slightly more concessional, such as extending the maturity of the loan, ways that give a bit more breathing space to borrowers. When you say extreme recovery strategy, that has a very ominous tone, and I think it kind of rings bells around some of the cliches of China's debt trap, right, or the seizures of assets. Everyone has had the case of the port in Sri Lanka that was supposedly appropriated by a Chinese company, but actually that single case is not an asset seizure, is not a debt for equity swap. It had, was completely independent of the debt that Sri Lanka owed to its Chinese creditors, and is, I think, at this point, a quite well deconstructed myth. So we have not seen any kind of extreme recovery or asset seizure from Chinese lenders. In fact, I think because of the Sri Lankan case and the optics that it's created, it does make certain valid instruments for debt relief, such as debt for equity swaps, that has been kind of made less palatable because of the kind of controversy around this perception. So in most cases, what we do see is just, let's say, kicking the can down the road. You keep pushing the problem a little bit further into the future. You try and work with your borrower to, even if they can't pay you now, well, let's try and make it so that they can repay in the future. To have any kind of extreme recovery, I think it does create not just it's not just a sort of financial transaction, right? It would be a very political move, and it would not work well in China's interests either as a political actor. I think Kanye also wants to comment on this, so I'll turn over to him.
Yes, Kanye, please proceed.
Thank you. I think first, on Hambantota, that's the Sri Lanka port, I think what you have is actually a case where the government agreed to lease for 99 years a certain plot of land. And the lessee actually prepaid everything, okay, upfront, so that the government can use that funds to not pay off the Chinese, but Western creditors. Okay, so I think that is a very well deconstructed myth, as Yunnan mentioned. It is not a case of asset seizure. If by extreme enforcement, we're thinking about something like, like the US going into a country and taking off the customs duties, like back in the early 1900s, that I don't think any country has appetite for that, right? Okay, certainly not China. With that being said, what's the legal duty on Chinese lenders to recover or sino-show? As I mentioned, there's personal accountability. Part of that involves, if things cannot be restructured, exhausting all legal remedies to recover. Okay, so what that means is there's a duty to, and they don't necessarily can take into account the costs of recovery. They have to exhaust remedies, even if the recovery is zero. Okay, I haven't seen any cases of where that actually has been done against a sovereign. There are political and diplomatic issues around that, but certainly against commercial borrowers, that's a very clear understood fact. They have to exhaust. Even if they understand the borrower is bankrupt, they cannot pay, they have to go through with arbitration, take all enforcement measures before they can close the file. Okay, and there's no reason why that would not be the basic requirement, barring certain instructions that they should not do so.
Okay, quite interesting. Yeah, so we're coming towards the end of this session, and I would like to invite the panelists to just give their quick thoughts or summary or words before we wrap up. So Yunnan, anything you'd like to say?
Just quickly, I think one of the key takeaways that I want to push is that when we talk about China as a lender, we have to remember that it is not a homogeneous actor. There are many different Chinese financial institutions at play that are providing many different types of financial products. And all of these have their own discretionary channels of negotiation and potential scope of outcomes. And I think it's really important to be completely familiar in looking at who you're working with and what avenues of leverage or what political strings can be pulled with that particular institution. We have institutions and actors within China's bureaucracy that are trying to be very collaborative. I'm thinking in terms of the Ministry of Finance, for example, that works very closely with the IMF and is participating in the common framework. But at the same time, there are also other institutions with their own incentives and their own agendas that result in a very fragmented kind of system. So I think it's really imperative and important for borrowing countries to understand who you're talking to and how to talk to them.
Thank you very much for that intervention, Yunan. Rodrigo.
Thank you, Stan. Very briefly, just as a wrap up, 1 minute, I would say I'm not disassociated with reality, and I perfectly understand the additional pressure that the current health crisis has put on not just the African continent, but the entire world. But I also think that we need to be realistic, and we need to assess whether we are talking about a temporary liquidity problem or a solvency issue. And we also need to assess whether it is pre or post pandemic, because the treatment that you as a country, the treatment that you would expect will be completely different if it's a temporary liquidity crisis or it's a solvency crisis, and whether it was pre-COVID or post-COVID. Having said that, the reality is that we cannot ignore the fact that there were two initiatives were developed. The first one, the DSSI, and the second one, the common framework. And the common framework includes China. Again, we cannot, and this is something that was very prominent with the discussion about Brexit, is you cannot have the cake and eat it. So basically, if you want to get some kind of breathing space, you cannot expect not to be punished by a credit rating agency, because that's the role, that's what we ask credit rating agencies to do. Of course, we don't like being downgraded. Nobody does, but that's the role that what they are paid for. And finally, I would like to finish basically just with a simple example to illustrate some of the issues that we were discussing. Is if you have a mortgage and you explain to your bank that you cannot pay for whichever reasons, it's not that they're going to tell you, yes, they're going to tap you in the shoulder and say, yeah, go and keep on enjoying life and having fun. They will probably repossess the house. For reputational issues, they might not do it immediately, but they will end up doing it sooner or later. And this is where basically I'm coming with the example of the DSSI and the common framework, because that's what they are doing. Basically, they are not forcing your hand now because of the health crisis, but sooner or later you will have to face the music. And Stan, I leave it there and I hand over to you.
Yeah, thank you so much, Rodrigo, for those words. Livingstone, I'm not sure whether you're still around for your final words.
Stan, while Livingstone comes in, just basically to wrap up, it's about prevention rather than curing. That was where I was going with the example of the mortgage, etc. But basically, it's all about prevention rather than curing. Sorry, Stan.
Yeah, I have that in my summary. Thank you. Livingstone. Yeah, if Livingstone still not online, Kanye?
Thank you. Just very quickly. In approaching Chinese lenders with a restructuring proposal, the most efficient approach is to talk to them and present a proposal for discussion that is fair to all parties, that is reasonable and reasoned and sustainable. Okay, as Rodrigo mentioned, I think yes, it's very important to get past the current hurdles, but it's very important to also demonstrate that that you understand this is a relationship and how we can proceed forward rather than always dealing with the next crisis. Ultimately, I think prevention and having the framework in place is the goal that we will all like to ultimately get to. Thank you.
Thank you so much, Kanye, for those words. Well, I think this is a session which we could continue discussing for the rest of the day because it's very interesting. And I would like to thank all the panelists and discussants so much for those interesting insights on this subject. So just to summarize what I've picked, coordination is very important among the African countries in dealing with creditors, not just China. And there's also the issue of flexibility. From the interventions by Kanye, we take note that, in fact, the Chinese, in terms of the commercial loans, there's actually flexibility to discuss the rescheduling terms of the debt, and it's important for countries to approach China with a very clear proposal in terms of what needs to be done. I think that's a window of opportunity which we can take advantage of. The other issue is about China not being a homogeneous lender. There are actually so many lenders within that. And I think it's important to know the lending terms and how we as countries can approach them. The DSSI and the common framework are great opportunities for us to deal with the current COVID-19 crisis in as far as it affects the debt obligations or dealing with the debt of the countries is concerned. But of course, we cannot take it to be a long-term solution to the challenges that countries are facing in terms of debt. And this brings us to the point which Rodrigo mentioned. Prevention is better than cure. We need to go back to the basics. What are we borrowing for? We need to do the due processes when contracting loans. What are we contracting these loans for? Are they contributing to development? And more importantly, transparency, recording, but also not just transparency to the creditors or international community in terms of reporting, but even to our citizens at the country level as well. The issue of rule of law and fighting corruption are actually critically important. So I think as much as we are in this crisis, I think let's not lose sight of the fact that there are structural issues which our countries need to address. And I do hope that in taking the messages from this session forward, our colleagues at the CABRI can focus on some of these issues that the panelists have mentioned. So I would like to thank you so much, and I would like to now hand over to the CABRI organizers. Thank you.
Thank you very much for this discussion. Yeah, as you said, we could continue for quite a while. Unfortunately, time is always a factor, and so this is unfortunately what we have time for. And I think I'm looking forward to the days where we can have these in-person discussions and we can have more in-depth discussions around these issues. But yeah, so thanks for summarizing and providing the key takeaways for this discussion, Stan. I think what we also need to realize that I think with EPIC, the situation was a bit different because most of the loans were multilateral type of loans, and now we sit within a situation where most of the loans are commercial. So more than we see in the debt composition that most of the debt are now moving into commercial hands. So it brings a new dynamic to our environment. It's a new way of negotiation, and perhaps there's many lessons to learn in terms of how we manage the risk in our debt portfolios in terms of restructuring, and perhaps that is something that we can take forward from this in terms of supporting countries in terms of restructuring their debt. We know that, I mean, we're glad to hear that China is flexible and it's all about relations, and also prevention is better. So so perhaps one can focus on that going forward. So I would like, again, all the information shared. I think we come to the end of our discussions. We have 2 or 3 minutes left, or 5 minutes left. Is there anyone from the floor that wants to come in and perhaps comment on from your perspective on what was been discussed? Otherwise, I'm going to take this opportunity to and I know I might be in trouble for this, but if Neil wants to say have a last comment on this, I'm just taking that a wild shot here, but please, if there's anyone that wants to have a last say on this, anyone from Maris, from your side, if there's any other country that we have here on this policy dialogue. I mean, you're welcome to. You got our emails. We can talk later, and I'm sure we will engage again as public debt managers. Our last network engagement meeting is scheduled for the end of the year, and I'm sure that there will be, as debt managers, we can sort of engage and interact and see how best we can take this way forward. Yeah, so very important that we focus on getting the house in order. There's tough decisions that one needs to make. I mean, in South Africa, we sit with a similar problem in terms of tough decisions that needs to happen. There's risk from all, in the opening remarks of Neil, a lot of uncertainties, a lot of vulnerabilities, and it's still important that we build those capabilities, strengthen our processes, and focus on those basic things that can help us through difficult times. So from me, Neil, I don't know if I was taking too much of, but please, if you can have a final say, I'll appreciate it.
Thank you, Johan. I think for the delegates, they need to know that that you, Johan, you've been involved in this area of work for over 26 years. So when you get an opportunity to be in the company of debt managers, it is difficult for you to let them go. So whenever we go over time for a policy dialogue, especially the virtual one involving debt managers, it's only because Johan likes to be in the company of debt managers. But let me thank everyone for your participation. I mean, we've been speaking about this topic of contract negotiations and the capabilities related to contract negotiations for some time, and I'm really pleased that we have had such amazing inputs from a wide variety of participants, both from country debt officers, as well as academic institutions, think tanks, and also some market players. It's exactly why we have these policy dialogues, so that we can dialogue with the relevant stakeholders. So thank you very much. We always knew that a discussion or a dialogue on contract negotiation was going to be a frank one, where the issues were going to be raised in a transparent and in an open way. And there's certainly a lot that we therefore take from this dialogue that informs not only the work that we do going forward, but also informs the policy briefs that we prepare. I just want to close by once again thanking all of you, and in particular to thank the Bill and Melinda Gates Foundation for supporting this dialogue, the African Development Bank, and in particular the Africa Legal Support Facility, our translators that make it possible for us to have this dialogue in the three languages, and then also just the technical support, and finally the CABRI staff that has been so diligently preparing and putting the program together. And then also, I mean, thank you more specifically to Johan that leads our work on public debt management. Thank you very much. And I mean, if we were all gathered in the same place and catching flights within the next hour or so, I would have greeted you all Safari and Jema, safe travel. But I suppose I need to greet you by saying Salani Kakushle, stay well.
Thank you, Neil. Thank you, Neil. And yeah, so I think that we have kickstart this topic. There's many. Hopefully, we can turn this into some training event and in-country work later on. I mean, that is the approach of CABRI, that we want to work with the individual countries at the end of the day. So thank you very much. This was, hope we will see you again. Kani, we were very privileged to have you on board. Rodrigo, Johan, thank you very much. Everybody participating. We will put together the necessary documents and share it with you, but please, the network is established, the platform is there, we interact regularly as debt manager, and don't, please let's continue our interaction and work together going forward. So with that, all I can say is until next time, thank you very much.